I'm the Director of the Centre for Commercial Law and Regulatory Studies, affectionately known as CLARS, at Monash Law School. I wish to acknowledge the traditional custodians of the land on which I'm calling from today, and I pay respect to elders past and present, and I extend that respect to other Aboriginal people who may be participating in this event. So, welcome everyone. It really is a great pleasure to welcome both our in-person participants and our online participants of this hybrid event today. The topic is Researching Tort Law in Australia, Emerging Voices and Fresh Perspectives. I'm not going to be able to stay for the entire conference, but I know it's going to be terrific. And I just wanted to thank a few people before we get underway. So this is a, thanking forward. First of all, I wanted to thank Professor Claudio Michelon from the University of Edinburgh. Thank you for coming to Australia, because it was really your visit to Australia that got Nick and me speaking, and we just thought, it would be great to organise something around your visit, and having you here is such a delight for us. Also, I want to welcome our speakers from around Australia. Thank you so much for either tuning in online or coming and visiting us in Melbourne, and we hope it'll be the first of a number of visits that you'll make to Monash Law School. It's really great to have you here. I'd also like to thank the people behind the scenes that are going to make this all happen today as seamlessly as we can. Aniran Hani and Janice Hugo, thank you both so much for all your hard work. And then the real person, Nick Sananas. Nick has done all the heavy lifting in bringing this conference together. And I think my colleague Paul Burgess is also going to be in the room. And Paul, we're really grateful to you for being here as well. So the conference is really looking at fresh perspectives in tort law. We're very interested in private law in the Centre for Commercial Law and Regulatory Studies, and we saw this as a really important opportunity to bring together historical, doctrinal and practical new ideas in relation to tort law. The other thing I just wanted to mention is we're going to be really welcoming questions. So we're going to have speakers, but then we're going to have questions, and we want to have questions both from the people who are in the room and also for those of you who are online. So if, as the speakers are speaking, questions do occur to you, please feel free to use the Q&A box in order to put your questions in, and we'll try to get to as many of those as we can. But having made that introduction, let me pass over to the man of the moment, Nick Sananas, who's done it all. Over to you, Nick.
Thank you very much, Jennifer. I think I've turned myself off mute. Let me double check.
Yeah,
yes,
no, I can hear you.
Excellent.
It's all good.
All right. So thanks again, Jennifer. Good morning, everyone. I'd like to thank you. I'd like to begin by warmly welcoming you all to the CLARS Torts Workshop, Researching Tort Law in Australia, Emerging Voices, Fresh Perspectives. I might echo and expand on a few of the points that Jennifer's just made, starting with a couple of introductory remarks about the origins of the idea for today's workshop. So it originated not too long ago, some 8 or 9 weeks ago, with the prospect, as Jennifer mentioned, of our research centre hosting Professor Claudio Michelon from the University of Edinburgh in Scotland at some point in the middle of the year. And at Jennifer's prompting, the centre members started thinking hard and very quickly about whether Claudio's visit to Melbourne might form the basis of a larger, more encompassing event. But what such an event might entail wasn't immediately clear. And as an early career tort law researcher, I for one felt that more could be done to form new ties and strengthen existing ties between tort law researchers across Australian university law faculties. I joined Monash as a lecturer in February 2020 after a 3 or so year stint in the UK as a doctoral researcher. So just as the COVID clouds were circling, and I'll come back to COVID in a moment, but 2 or so years into the position, and of course COVID certainly made this worse, I felt I had still not met, much less got to know, fellow tort law researchers in Australia, particularly those at the early and middle stages of their careers. So that's bit of a background on what motivated the event. And the motivation really was to convene not so much a conference, but a workshop coinciding with Claudio's visit, and which would give Australian tort law researchers the opportunity to present on a research topic, however well developed, in which they are presently engaged. So I'd like to very warmly thank those who I can see in front of me gathered in person at Monash Law Chambers in the city, who graciously accepted my invitation very quickly to participate at today's workshop, whether in the capacity as presenters or discussants. In particular, I'd like to thank Tina Popper from RMIT, who I had a conversation about this very early on, and she expressed her enthusiasm for the kind of event I had in mind, and it gave me confidence that I wasn't the only person who thought that there was a need for the kind of thing that I had in mind. So thank you, Tina. I'd also like to especially thank, echoing Jennifer's thank yous, to Michael Douglas, Martin Alcock and Andrew Fell, who have travelled or at least tuning in from interstate, and of course in Claudio's case from Scotland via, I think most recently, Sydney, Claudio, if I'm not mistaken. So thank you very much. But of course, and this is me now circling back to COVID, Murphy's Law dictates that when something unfortunate can happen, it of course will happen. So as late as Friday last week, the plan for me, of course, was to be there in person convening the workshop, but due to contracting COVID at entirely the wrong time, I'll have to undertake as much of that role as possible via Zoom. A few people I'd like to thank. My Monash University colleague, Paul Burgess, on very short notice, Paul agreed to attend the workshop in person in my physical absence and play the important role of host. Although not a tort law researcher himself, in these settings, Paul is as natural a host as I've seen in action. So he's the perfect person to have there in my absence. And I'd also, of course, like to thank the professional staff of the Monash Law faculty, Anira and Hani and Janice Hugo in particular, without whom the event wouldn't have been possible. So a couple of housekeeping matters, and we're looking good in terms of time, but I'll just address a couple of these points before we get started. The workshop's going to involve each presenter presenting research around a particular law, tort law topic. A breadth of disciplinary perspectives I know will be brought to bear, including doctrinal, practical, theoretical, and historical. Some of the presentations will be made on the basis of journal-length research articles that have been more or less already produced. Others will be made on the basis of research that has recently commenced or is still in progress. A few remarks on structure, more so for the benefit of those tuning in online. The workshop is divided into two main sessions, a morning session and an afternoon session. The morning session will run from 9:45 a.m. or from 9:30 a.m. till 12 p.m. midday, with a 15-minute morning tea break from 10:45 till 11 a.m. And the afternoon session will commence from 1 p.m. and run to 2:30 p.m. and we'll round things up at around 2:30 or just after 2:30. And of course, there'll be a 1-hour lunch break from 12 p.m. to 1 p.m. in the afternoon. The morning session, as the schedule hopefully makes clear, will consist of 4 presentations, and the afternoon session will consist of 3, so 7 in total. A total of 30 minutes has been allocated to each presentation. Each presenter will have about 10 minutes or so to present their research, and a discussion of hopefully 20 minutes or so will then follow. The aim is for the ensuing discussion to be commenced by each presenter's assigned discussant, and then towards the end of the 20-minute discussion, we hope to be able to put to the presenter any questions that online participants may have sent through. So that's the game plan as far as the day is concerned. I'm not sure if anyone physically present at Chambers has any questions regarding housekeeping matters, if there are any uncertainties around how things are going to proceed. Everything's okay? Good. Excellent. Well, without more ado then, we've got about 5 minutes to spare, but I'm very happy to get started slightly before 9:45. I might pass over to Paul in the room to introduce our first speaker. Thanks very much, Paul.
I'm going to take my leave, but I know
Okay.
you'll all have a wonderful and fruitful day. So goodbye, everyone, and thanks very much, Nick. Bye.
Thanks, Jennifer. Bye-bye.
Thanks, Nick. Thanks, Jennifer. I won't echo all of the thanks in great detail, but thank you, everyone. Thank you for coming. Thank you for the admin people. Thank you, Nick, for throwing me under the bus. Especially in my apparently pure skill as host. Obviously, that doesn't take away from my normal environment of public law. It is really wonderful, actually, though, to be here. In case anyone who doesn't know, the relationship between Claudio and Claudio was my PhD supervisor. I felt sorry for him in many ways. He did bring to bear all of his private law knowledge, though, in recommending books. The first thing he ever recommended I should read is Bully for Brontosaurus, so I could read a history of the QWERTY keyboard. I don't know what that has to do with legal theory or the rule of law, but it did also make it into my PhD. So Claudio, thank you for that. I am hoping that you're going to bring that up at some stage during today's presentation. I don't know where it's going to fit, whether that's primary or secondary duty, I don't know. But that is your paper. Primary duty is not equal to secondary duty. Claudio, I'll pass over to you.
Thank you very much. So before I start, because we have short period of time for presentation, let me just thank you all. Thank Monash, of course, for organizing, and Nick and Jennifer and Paul and Martin for agreeing to comment on the paper. So thank you all. And I'm worried at time because I've been dining on this paper for a few months now, and I normally present it in about 45 minutes. So I'm going to just get to the business of trying to present the argument. So this starts with this is one of those papers that is more or less finished, the paper itself. So this is coming out. I'm waiting for the proofs from OUP in the next few weeks, perhaps. But one of the reasons why I came to Australia is to take stock, and the reasons why I wrote this paper I'm not still fully satisfied with where the debate is. So one of the reasons I came to Australia was to spend a month now trying to decide whether this is going to become a book. Not necessarily this paper, is to be probably a small part of the book. So let me tell you what I think the problem is that I'm trying to tackle in this particular paper. So when we talk about remedies and secondary duties in tort law, there are different registers in which you can talk about that. One of them is the normative register. So what makes it right that we have this particular remedy or a remedy at all? So what's the underlying justification for a remedy to crop up? And of course, one of the main voices in the field is Ernest Weinrib and in the whole Toronto school, Ripstein and others. And the idea they have is that the remedy is justified because ultimately the remedial duty, the duty to pay damages or in some cases other duties, but the remedial duty is actually identical to the primary duty. So my duty to drive carefully is the same duty as a duty to pay compensation. And a whole debate started around that, whether that's actually a feasible thesis. And so my first concern in this particular part of the project was the debate seems to be in the wrong key. So the arguments that have been fenced by the parties seem to be just the wrong arguments. They're not the arguments that are able to settle the problem. So what I wanted to do is in the first part of this paper, I tried to show, to do some extreme charity and try to show that if you apply charity, both positions can resist the pressures, the cross pressures of the arguments they are presenting. So both the continuity thesis or the opponents of the identity thesis and the defenders of the identity thesis wouldn't be knocked out by any of the arguments that are now being debated and circulating. And the reason for that is because it's a different register. They're presenting arguments about something else. So the idea is to try, in the first part of the paper, is to try to show that, try to be generous with both the Weinribian canon and the anti-Weinribian canon, and show. I think if I succeeded, I show that actually both theses, against the background of the arguments that have been put forward against them, both of them are perfectly okay. I'm going to say a bit more about that in a minute. But of course, my main concern is not that. So if the whole debate is in the wrong key, So what's the right key to have this debate? The second part of the paper starts to not give an answer, but to structure an answer. Well, to try to outline what an answer would look like, what an answer could look like. And today I'm going to focus more on the second part of the paper, because I think that's probably where I want to hear more from you, because it's what is going to become, if it becomes a book, it's what is going to become the book. So I'm going to expand some of those things that I waved in the direction of in the second part. And so today I'm going to talk very little about the debate today, a bit more about what I think should be the debate, and then towards the end, just for 2-3 minutes, I'm going to tell you what I think needs to be done yet. Right, okay, so far so good? Yeah, okay, good. So what the problem is with the debate is that there's one obvious objection that you can make against the identity thesis, right? And it's very intuitive. It speaks to all our intuitions, that clearly the duty to pay you £300 or £1,000 is not the same as the duty to drive carefully. They seem to be different, right? And why are they different? Because our deep intuitions are that the way we specify duties is by the action they ask us to perform. So those are two different duties, right? Now, the identity thesis is going to try to claim the opposite. Say, well, that's in the surface, but actually they are the same duty. Now, that goes against very deep-seated intuitions. And in fact, John Gardner, when he wrote about this, he raised precisely the same objection. So look, clearly we specify duties by the action they perform. So those are different duties. Therefore, the question of what's the normative relationship between them is still open, because if they are the same duty, there's no question. Yeah, the elegant bit about the identity thesis, the thing I like about the identity thesis, is that it's so simple, right? If it's the same duty, you don't have to justify why I have a remedial duty after I breach the primary duty, because the structure is very simple. My duty is a duty to either phi or not phi, or phi or phi prime. I cannot phi anymore. I cannot not drive. I cannot avoid not having driven carefully now, because that's in the past. I already drove recklessly. Therefore, I now have to pay compensation. So it's either a duty to phi or not phi. I cannot phi. Sorry, phi or phi prime. I cannot phi. Well, phi prime. Very elegant, very simple. Gives an answer. If the identity thesis is correct, that's it. The question, the normative question. Stephen Smith in the book on remedies that he published a couple of years ago, they say, well, there's the normative question and the sort of doctrinal question, and the normative question would have been solved. But I think, and of course, what Weinrich does is to say duty specification. So he needs to object to duty specification, yeah, because if duty specification on the basis of the action specification of duties is the right thing to do, yes, well, that clearly isn't. So he levels a few arguments against our intuitions. He says, look, clearly you can have two duties to do the same thing, and they're different duties. So according to action specification, if you specify duties by the action they perform, if the action is the same, how can you have two duties? I mean, no, they have two. So for instance, the example I give there is a legal, a statutory duty and a contractual duty. They are different duties. They have different vicissitudes in their lives. One might be subject to the statute of limitations, the other doesn't. One can be waived. So they clearly are different duties. They have different life paths, but they're the same action. A duty to inform, they're the same action. So clearly, Weinrich thinks duty specification is wrong because of that, and also because that's a bit less convincing, I think. Also because there are so many ways in which you can perform a duty. Yeah. So if I owe Sharon £1,000, it could be. Sorry, I'm still in the pounds register, not the dollars. Apologies. But it could be a check. It could be a pay money into your account if it's not specified in the contract, say, between us. It could be, if it's cash, it could be a number of different combination of cash denominations or notes. The notes might be actually varied. So there's in numerous countless, really, ways in which the same action, the same duty can be performed. Those are different actions. So if Bribery thinks if action specification is right, you should have millions of duties when you have a duty to pay £300. And that cannot be right. Now, so he thinks, and that's in the 2013 book, Corrective Justice, 2012 to 13. Oh, that book, yeah, 12, yeah. But there's a way, of course, to counter these objections. And the way to counter the objection is just to say, look, there are two ways to think of action individuation. It could be a sufficient condition for individuation, or it could be a necessary and sufficient condition for individuation. So if it's a necessary and sufficient condition, yeah, those objections probably, well, but certainly the first one seem to obtain, yeah, because I have two duties and clearly only one action. But what you can say is that you can have a more fine-grained conception of duty specification. You might be able to specify the duty on the basis of the action or something else. So you can have different ways to specify that. So it's a string of criteria that you can use to specify. So one of them could be the ground, in this, the legal ground, the positive law ground. So in this case, it could be statutory or contractual, the example I gave you. So, well, it looks like if you adopt a fine-grained conception of duty specification, Weinreb is fine, but also John Gardner is fine. Yeah? John would say, yeah, okay, of course there are two duties here. It's the same action, but they have different legal positive law. They're grounded in different aspects of positive law. Okay. The trouble is that John's defense actually opens the possibility for Weinreb to say, okay, so what you're saying is that it's not simply about the action. Yeah, it's not because the same action could give rise to different duties. Yeah, yeah, okay. So if you do that, so that's me sort of doing telepathy with Weinreb or Weinrebians, right? So that's simple. So what you can say is that if there are other things that can specify the duty, why do you need the action? If you're accepting that there are other things like the legal grounds could specify the duty, why couldn't it be just the other things? Give me a good reason why it cannot be just the other things. And if it can be the other things, why not the right, the Kantian rights that you have? Why not that? And John would have nothing to say against that. So what you have here is a complete stalemate, right? The two of them are arguing against each other. They cannot prove that they're wrong, but they cannot prove they're right. But why? Because what they're debating here is something to do with the metaphysics of duty. It's a theory. It's really what's the ground floor of duties in a metaphysical ground floor. What do you find when you find duties? Yeah, what kind of entity is a duty in? And honestly, I don't think that even if they could decide that. So I do think that action specification has a lot going for it, for many reasons. But even if I were right, should Weinreb just say, oh, okay, fine. So clearly I'm wrong? No, because the debate, what he's trying to push, the point he's trying to push, is completely resilient to what happens at the metaphysical ground floor. So even if that were the case, you would say probably, yeah, okay, let's call it different duties. But my point here is that there's the same normative grounding. So it's a substantive normative debate, not a metaphysical debate about the structure of duties. So even if I proved conclusively to Weinreb that duties have to be specified in terms of actions, he would come back to me and say, okay, what you call duty, it's fine, you can have that. But what I'm saying is that from a certain perspective, from the perspective of the normative perspective of the spheres of liberty, of blah, 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 they are the same. So clearly, under some perspective, they can be seen as the same, yeah? The two different things, they are different or similar under a description. So under some description, even if it's not the one that's at the bottom of the metaphysics of normativity, under some description, they can be seen to be the same. And that's all he needs. You say, well, they're the same normative ground. So the debate looks like it's a metaphysical debate. It's presented in metaphysical language. When Weinreb writes, he talks about Aristotelian metaphysics. When John talks about this, he talks about duty specification in the way analytical philosophers talk about that. But it's not about the metaphysics of duty. So the first concern of the paper is to say, look, let's just move this debate to the actual arena where the debate can be won or lost. And the actual arena where it can be won or lost is the arena of substantive moral considerations rather than metaphysical considerations about the structure of what a duty is. Okay, that's a long first part, so I'm going to shorten it a bit now. Okay, so what at the substantive level, what's distinctive of the identity thesis, the thesis that says that they're the same? The idea here is this, is that all considerations, normative considerations, that bear on the existence of the primary duty, whatever reason you have for having to drive carefully, are the same reasons that bear on the existence of the remedial duty, right? So the point of the identity thesis is to say that the normative justification for primary duty and secondary duty is exactly the same, right? So there's no extra reasons that bear on the remedial duty, and if there might be prima facie or apparent reasons, but they are not actual reasons. The actual reasons they have to be the same. So now that's counterintuitive in some respects, right? So we know that sometimes other reasons are facts that point in one direction or the other, yeah? So an example that some people use, and it's going to be used so I'm going to use it later on as well, that sometimes a particular new precedent, when a court has decided on torts, one thing that they take into consideration is whether or not they're not going to create a mess in the legal system by granting this particular right, by interpreting the law in such a way that affirms that. Now, that's a common thing that courts do. They think about floodgates arguments and things like that. They think about those things. So prima facie, at least, courts often have other concerns that cannot simply register as reasons, the reasons why you should drive carefully. They have to do not with the individuals involved, but with, for instance, the ability of the legal system to actually deliver goods. So, as Gardner and others put it, positive law is a public good. Yeah, not only positive law is a public good. People actually guide their actions, and clarity in positive law is a good thing. And it might be that that's sometimes a weak argument, but it could be a prima facie, at least. I don't see why judges shouldn't actually take into consideration the fact that they're creating a mess, right? And also there are other things. So there are many cases in which corrective justice is involved, in which we don't have any law, right? So if to use the example that everyone uses, if I promise my children to bring them to the beach tomorrow, and I don't, clearly I wronged them, right? But we don't want the legal system to actually enforce that. Well, I certainly don't want that, because otherwise my life is going to be a mess. Mm-hmm. My children are very litigious, and I break my promises very often. So yeah, you do the math. So there are certain things we don't want to be reaching the legal system, and the considerations that bear on that seem to be considerations that don't have to do with the bipolar relationship between them. So my worry here is this, and I think that's the worry that we all have in this field, is what would a defender of the identity thesis say faced with those considerations? They can say three things. I might be wrong. If there's a fourth, this is the moment for you to let me know, especially you, Martin. But they can say, look, of course, there are other considerations that might bear on the availability of remedy or not, of course. But what we are trying to do here is to get but those are not private law considerations, they're not tort considerations. We are looking here for the pure version of, and in fact, sometimes you do that. Yeah, sometimes in lab conditions, in order to know how the water reacts to this or that, we use water that's much purer than you can find in any real world instantiation of water. Yeah, that is very pure. Sometimes you do that, and that has some value. But then, of course, the answer could be, so what? So you're actually not explaining tort law, you're explaining an aspect of tort law. And I would have no objection to that, if that's what you're trying to do, lab conditions and all that. But that wouldn't explain why so many of the Weinreibian canon gets really mad at court decisions that follow other logics, right? So because they say, but it's not only about lab conditions. We think that courts should be actually following this. Second possibility is the most intriguing one, the one I think I have to write about still, is this idea of a system of rights. Kant mentions that in in the metaphysics of morals, towards the end of the first bit in which he discusses the particular legal institutions. And Weinrib and others picked up and say, look, a system of rights could accommodate some of those considerations. So I don't know Ernie personally, but he saw this paper online and wrote to me and sent me the chapter of the new book that's coming out a couple of months from now. By all accounts, I don't know him personally, but by all accounts, he is the nicest person on earth. It's like he's probably a version of Neil McCormick, who was my supervisor and was up till then the nicest person on earth. So he sent me, and actually he does that. He goes through, he tries to build a system of rights, including some considerations like you only have a right if the legal system somehow is not worse off as a public good, and so some of those public considerations could be folded back into the system through this idea of a system of rights. How it can be done, I'm not sure, and whether it can be done, I'm not sure. So that's part of the project of the book, where at least one chapter is going to have to deal with that, whether a system of rights can cope with all the considerations that prima facie bear on remedial duties, and if they can't, which ones they can, which ones they cannot, and so on. And the third possibility, of course, is just to stick to their guns and say, yeah, those considerations are just prima facie relevant, but then they have a very high justification burden, right? Because they have to justify not simply that they are defending a very important value, the autonomy of, well, can I have an extra minute, Paul, just to, yeah. A very important value, the value of autonomy, but that's the only value, or at least the systematically, indexically prior value to any other value. So in the conflict of, so a bit like John Rawls, yeah, with another Kantian, with the first principles of justice being systematically, indexically prior to the second principle of justice. So the idea is that this value might be either the only value or the value that always beats any other value, right? So it's a denial of a pluralist conception of tort law. And in fact, I think that's my problem. So I haven't closed my thinking about this. It might be that it turns out after I finish the book, I just throw it away because Weinrib was right all along. So I don't know. I'm very open to that. But my intuition is that law in general and private law in particular needs to be conceived in a more pluralistic key. There are more things that can be brought together, and sometimes, at least sometimes, private autonomy of the individuals is going to have to give way to other important considerations. That's not to say that this is not it's not the central consideration in tort law, but it cannot be the only one. And the identity thesis implies it's the only one. So that's my beef with the identity thesis. But I might be wrong. This is a finished paper and a highly unfinished project. Thank you very much for listening to me, and looking forward to your views. Thanks.
Thank you. The former supervisor says, can I have an extra little bit of time? It's really rude to say no. You were so kind when I was always late with my chapters. And also the fact that it was very nice to start thinking about buying and not buying for the first time since Scotland, so thank you for that. We're going to go on to the discussion stage. What we'll do, we'll hear from Martin in a moment. If there's anyone online who wants to start throwing out any questions now, there's a Q&A function that they can do. But of course, once Martin has said his piece, we'll be looking in the room and online as well. But feel free to start. So I will pass on to Martin, who's all the way from Edith Cowan, another one of the great UA contingent, heading to Melbourne. I've seen many in the last couple of days. For some comments on Claire's paper.
Thanks very, very much, Paul. Now, have I literally got like 10 to 12 minutes just to talk?
Yes.
Oh, what a treat. I can't get anyone to listen to me at home. My wife rightly identified me as the person with the least to contribute. But I can say what a pleasure, both to be invited to come here and to be on my topic that in Australia is so difficult to do, and then to comment on this paper. So it's a triple treat. Claudio, what a great paper. Yes, needs to be a book. Please write a book about it, because this is, my background. I did my PhD, finished it in 2018, but I've been sort of traveling around doing conferences, talking about Weinrib's corrective justice theory as it applies to my own area, which is psychiatric injury, exploring the Kantian right and how that right to bodily integrity might extend to mental integrity. If you're interested in that, I've got a few bits and bobs about that you can go and read. But the Kantian stuff it's always left me unsettled in the very way that you've identified. I have to say, like, the way you write is actually quite poetic. I have to. So I'm going to be stealing some of the things that you talk about. The debate being in the right or the wrong key, it's perfect. I wrote a paper in 2017 in the Tort Journal where I spoke about scholars talking past each other. But what I was getting at was it being in the wrong key. That's what I was talking about. Now, when you express it in a way like my PhD supervisor, Des Butler, who's sadly no longer with us, he said I had an inelegant way of expressing myself. I'd like to think it's not that bad. I like to think I'm a clear writer without frills. But saying the right thing in 2 words is elegant. So the right key or the wrong key, perfect. And talking about, my first question was, well, what key do we need to move the debate to? And you say the pluralist key. Again, really nice. And I think where Weinrib attracts a lot of criticism, and in many ways rightly so, I agreed with all of your criticisms of the identity thesis, even though for all intents and purposes, that's what I'm working with. I don't disagree with any of it. I just think there's a lot of work it can do in my particular more practical area, which is how do I build the right? And for me, the Kantian right based in the idea of autonomy, free will, people being ends in themselves, the right to have freedom of interference with your mental integrity is as important as your physical integrity. The mind is the organ through which we operate in the world. And so, but in my work, I've spoken about the right sort of expanding and contracting as knowledge of the interference with that right works. And then that shapes, obviously, the duty and the right being the same thing. The very difficult thing for those of us working with this kind of Weinribian perspective is to say, how do we explain all these other influences which are clearly there? You can pretend they're not there, but they're there. And in my work, I go on to explain that, for example, floodgates arguments in the area of psychiatric injury are quite possibly principled arguments based in Kantian thinking. And that was an argument I made, saying that if a right was going to lead to an opening of a floodgates, for example, my right to mental integrity expands to such an extent that it was to lead to a floodgates argument, then the right itself would be inconsistent with the equality, the normative equality that one would have been arguing for. And so in many ways, that floodgates argument is an argument of principle, which can be brought back to the Kantian purposivity type way of thinking. But I always sensed that was in need of much further development. It was very much a frame, a sketch of an outline of a potential response to that. So this is going to be an important bit of work. So please do write that. My questions really are: what is the normativity going to be? And you've answered that by talking about the Kantian system of rights, talking about it in a pluralist key. I mean, that word is going to probably upset perhaps Alan Beaver and maybe Ernie Weinrib, but sometimes it's about maybe just the terminology or something, because what you're getting at is entirely correct. I mean, I don't think anyone really would argue that we need to think more about what the law is bringing in, and not all of these apparently extraneous considerations the courts are looking at are actually extraneous, and many of them can be brought into something of that Kantian normativity. So I don't have anything to add at this point, apart from saying, please please do that work. I'd be very interested to read it. It was an absolute pleasure reading your paper. I've got a couple of questions, if you wouldn't mind me asking you. Where do I start? I've got a bunch here. So my first question when you started was, what was the normativity? What was your proposed normative underpinning of the continuity thesis that you were going to discuss? And you did answer that. You said you were going to sort of go back to the metaphysics of morals and talk about rights in a more broad sense. And that is exciting because I'm not a Kantian. I'm not a philosopher. I was a lawyer, did my PhD in private law, interested in it, and then realised, there's this wonderful philosophical world that I could enter into. I don't consider myself an expert in the slightest. I did my PhD on it, focusing heavily on it, but it's still very new. I feel so. I don't feel I have the skills to do that work. So I would be very much hoping that someone like you would do it, and I could piggyback off you. So what is the normative underpinning of your continuity thesis? If you could perhaps just expand a teeny bit on that. And then where would you say where you're going with the continuity thesis? Where does it sit within the field of other theories, more broad theories like Goldberg and Tversky's civil recourse theory? That's the other big question. Can I give the floor back to Claudia?
Absolutely. And if anyone has any questions in the room while Claudia is answering, give me a wave and I'll come on this. Claudia.
Many thanks, Martin. That's so. Yeah. So we I think we are on the same page. So the problem for me is that I don't know how pliable the system of rights argument is. So I don't know what can be included. So in the extreme, it could include every consideration that we find relevant that doesn't pertain specifically to the parties, but it pertains to the rights the parties have in the context of everyone having rights. Yeah. So there's a sort of inflationary conception of the system of rights in which all those prima facie reasons that worry me, they would be folded back into a system of rights. In which case, I'm happy to be a Kantian. But I don't know how pliable it is. So there's another version of that, which is deflationary, which would be able to account probably for floodgates arguments, I think so, and state of the legal system sort of arguments, because Kant, in the middle of the Metaphysics of Morals, he talks about the need of public law. The public right comes in part from uncertainty about private entitlements. And so we need someone to settle things. We need a judge to say, look, this is yours, and the price to pay for that is sometimes judges make mistakes, and so there might be a deflationary element to that. So I'm worried that I don't actually have the full grasp. I've seen arguments both ways. So Weinreb himself, when he wrote back to me, some of the reasons I gave as possible prima facie countervailing reasons to reasons based on Kantian right, said, I don't think those are actually reasons that have anything to do with tort law. I think those are out of the question. And so I have this probably prejudice, right? So I have to keep constantly in check that any solutions that are monistic, that base everything in one value or one must. So there's a sense in which Weinreb thinks that's what Aristotle thinks, and I studied a lot of Aristotle for reasons that we don't need to. I don't think that's what Aristotle thinks. I think for Aristotle, the good is plural. It's objective. So what is good is not subjective. He's not a relativist, of course. But human good is not reducible to one thing, to one good, one value. So my intuition tends to be pluralistic in that sense, that there are multiple things of value for humans. All of them are constitutive of a well-lived life. And the way we rank them depends on specific circumstances. We don't actually have there's no one-size-fits-all for which kind of value should prevail over any other value. And I think ultimately that's what the Kantian would have to convince me of. You have convinced me that there's one thing, which is autonomy against your oppression to use usurping my sphere of rights, that is either, again, indexically prior to everything else. So everything else might have value, but it's subsidiary value, or is the only source of actual moral value. And for the life of me, no, it's not for the life of me. So perhaps they're right, but my intuition is, and so I've written about John Rawls. I think history was wrong. I've written about aspects of other attempts to insulate moral considerations from one another and say, well, let's just consider those exclusions by kind. They're possible, they're logically possible, but I'm not sure if they can be normatively justified. So the conclusion of this paper is the identity thesis might be right, and the continuity thesis might be wrong. But the burden of proof for the identity thesis is higher, because they have to prove not only that autonomy is a good thing, they have to prove that autonomy is the thing.
Only.
Yeah, it's the only thing, or the systematically private one. And that's a tall order, right? So it might be that. So as I say at the end, and as I told Professor Weinreb, so look, ultimately it might be right, but there's a lot of heavy lifting to be done here to vindicate a theory that reduces value to a smaller. So yeah, so that's. So thank you very much, Martin.
Oh, it was a pleasure. And look, I think not only is your intuition worth following, it's a really potentially important thing to do, because what we see is the Weinrebian version of corrective justice being pretty roundly unpopular, at least in Australia and in England. When I've been to Canada, I've been to the US and spoken about it. It's very it attracts a lot of weight. Whereas and Sharon, you use this as well, and you will have experienced the same thing when I feel like when I'm talking about Weinrebian corrective justice, I really have a heavy burden of proof, much heavier here than overseas. And I think you addressing that plurality issue and that potential issue, but in a way that doesn't just throw everything out, is potentially really important for us here in Australia, because it shows that there is value here, but more work needs to be done. So I think that's going to be really important for us, particularly doing this work here in Australia. I think the autonomy issue, I think the kind of idea of what this right does as an emanation of human free will is much broader than autonomy. That's my feeling. It's and that's where I think it can be explored more, and it can do more. And whether that means it protects a pure version. I like your use of lab conditions as well. That's nice. Whether it means that is the answer, and it's just that the right needs more being fully formed, or whether there's something else. It's important work, because there's no point talking about it in the abstract and not talking about real world conditions.
Yeah.
And that's what my work is, less in the analytical stuff. I feel that's a little bit beyond me at times. My interest is, how does this manifest in real world situations? Because that's, for me, much more important.
Yeah.
And there's much better people doing that work. But I think it's really much more convincing to say, here's a real problem, and what is the real solution or potential solution, and what benefits can this give us? So that really takes that work and makes it much more pliable. And I think the title of the practical perspectives and the doctrinal sort of could potentially provide a few more steps in the bridge for people like me who are working in more of the practical area. So yes, I'm really looking forward to that, and it was a pleasure. Thank you very much.
Thank you.
So thank you, Martin. Thank you, Claudio. I'm very conscious Nick is glaring at me. But, maybe that's just because it's a Zoom thing and he's got a big giant head on the wall. But I get this kind of, we're running over time, Paul, and sort it out. But obviously that was a great discussion. Thank you for the great comments. Thank you, Claudio. If we can say a quick thank you to our discussant and presenter once again. going to move rapidly on to Laura. Laura, apologies in advance that there is coffee over here. I know you can't get to that, but I'm thinking many of the people in the room may be tempted. So I'm sure it's not going to be anything to do with your presentation. I absolutely, without even reading the paper, I'm going to agree completely with the part before the semicolons, sue the police. As an ex-police officer, I think suing the police is an excellent idea. Laura, over to you.
Excellent. Thank you so much, and thank you for accommodating my online presence today. I'm so glad that it's been possible. Before I start, I just wanted to acknowledge that I'm joining you from Wurundjeri country, that this land was never ceded, always was, always will be, Aboriginal land. And as you would have seen from the document circulated, it's a very long and unfinished draft. So despite my mistitling of the document, it's not for further circulation beyond this group. But I'm really keen for feedback as I sort of refine it and polish it up for submission as a journal article. So I'm just going to run through like a breakdown of what I'm doing in each part. So I think everybody here is probably already familiar with the sort of ongoing crisis of Indigenous deaths and harms in custody, and that despite, you know, the amazing work of the Royal Commission into Aboriginal deaths in custody over 3 decades ago, that these deaths and harms have continued basically unabated, and that Indigenous Australians are still the most incarcerated people in the world, and that the over-policing and over-incarceration of Indigenous peoples is an ongoing crisis. There are a lot of different ways of understanding this crisis, obviously. I'm interested in the framing of this as a crisis of accountability. And I've been, you know, this paper came as a response really to me witnessing a lot of the activism and the literature that came out, particularly out of the kind of Black Lives Matter movement and the way that it's unfolded in Australia, and how we often see calls for greater accountability in different kinds, but civil liability is often really absent from that discourse. So I was like, okay, what is the potential role, the current role and the potential role of civil liability as a form of accountability in this space? Okay, so I guess my main argument is that while in isolated cases, it can be an effective mechanism for accountability for individual victims and their families, there are much greater potential, you know, there's a much greater potential for this to work as on a systemic level as a form of accountability, but that there are particular barriers blocking that, and that targeted reforms are necessary in order to unlock that greater potential of civil liability. Okay, so there's 3 main sections to the article. In the first of those, I sort of map out, it's pretty basic, mapping out the potential avenues for civil liability. And I'm drawing on specific case examples involving Indigenous litigants. So I look at trespass to the person, obviously battery, assault, and false imprisonment, and how these are relevant, particularly in circumstances, for example, of unlawful arrest or excessive use of force in custody, threats by police against victims as well. And then sort of noting in relation to defences that, you know, this sort of tends towards the political, you know, question, right? So because a lot of, you know, the use of trespass of the person depends upon what you know, was a lawful authority for that use of force, then this relies on things like paperless arrest laws, which have been shown to be, you know, racist in their effects in Australia, and political tough on crime kind of policies, and how this translates into legally authorised use of force, and the over-policing of Indigenous communities and Indigenous youth as well. And therefore that sort of can cut off what would otherwise be the possibility of trespass liability. I then look at negligence. Now, duty of care is well established and is often repeated in a lot of these reports, that it's really important that there is a duty of care, and that it's really important that police and prison staff know that there is a duty of care, because that's not enough. So I look also at breach and how this can be tricky depending on whether we're looking at the individual actions and use of discretion by particular officers, or looking more broadly at systemic failures. But also recognising that in this space, coronial reports can be really useful, because they have often set out in meticulous detail exactly what events have led to particular harm and death, obviously, occurring in these instances. And they can be helpful in terms of identifying systemic failures as well. I also then talk about, with relation to causation, how this is particularly tricky for Indigenous prisoners, because, and within that demographic, in particular for Indigenous women, because they tend to experience repeated short-term incarceration over their lifetime. And so drawing that chain of causation between a particular instance and treatment, you know, in custody with harms or exacerbation of harms over time can be really tricky. Also because, you know, statistics show, particularly for Indigenous women in custody, that, you know, something like 95% of these women have already experienced sexual assault, you know, domestic violence, and serious trauma as well. So each of these elements, you know, even just the basic sort of doctrinal requirements is made more difficult and more complex in the context of Indigenous prisoners. I briefly mentioned a couple of other potential torts: statutory duty, malicious prosecution. I'm yet to delve into misfeasance in public office. That might become a footnote. Okay, in the next substantive part of the paper, I look at, you know, beyond the sort of technical legal requirements, what are the hurdles, what kind of barriers would be plaintiffs facing in terms of access to justice? And again, considering how each of these relates to Indigenous communities in particular. And starting out by noting, of course, that given the over-policing and over-incarceration of Indigenous communities, the experience of many Indigenous people, I would say most even, is that courts are sites of punishment and incarceration, and the breaking up of families and the taking away of family members. So what this means, and of course on the other side we have the police, whose experience of the courts is the exact opposite. So what we have here is a situation where the communities who are most vulnerable to police mistreatment, most vulnerable to over-policing, and most burdened by that intergenerational trauma that is generated by that over-incarceration, possibly the least equipped to turn to the courts for redress for those behaviours and for those harms. Okay, other barriers involve obviously access to legal assistance and representation, particularly given the severe underfunding of community legal centres and Aboriginal legal services. I draw a little bit on a comparison with the UK there in the provision of legal aid for claims against police. I talk about statutory time limits and some sort of tricky issues around the interpretation of personal injury damages, and then sort of just recognising that the process of pursuing, you know, complaints and inquiries, seeking diagnoses, litigation itself, all require continued investment, financial and emotional, over a span of years. And that for Indigenous plaintiffs in particular, they're also going to be dealing with facing, you know, racial discrimination and bias by each of those institutions, you know, by complaints bodies, by healthcare providers, and potentially in the legal system itself. And, there may be significant intervals between an individual's period in custody and the resulting harm becoming known to them, becoming provable, becoming attributable to the defendant. All of those things are going to be more difficult for Indigenous plaintiffs. Okay, in the third substantive section of the paper, I look at the question of who pays and how much, discussing damages, drawing on a couple of case examples, particularly looking at the potential suitability of exemplary and aggravated damages in cases of police, severe police misconduct, and, particularly where there's a racial element to that. Then I talk about how the standard statutory thresholds and caps apply for damages for personal injury, and how legislation could also disallow particular kinds of damages. So looking at some case law examples in relation to that. And then looking at the tricky question of vicarious liability, which when I first approached this paper, I thought that would be quite straightforward, but I actually think that vicarious liability is really central to that question of accountability and how accountability can work in this area. So I talk about the long-standing common law principle of Crown immunity and how that's been abrogated in various jurisdictions in slightly different ways, with different formulations. For example, with the limit that there is no, that police tort claims can't be brought against the Crown when there is a claim for exemplary or aggravated damages, for example. Okay, in terms of vicarious liability and that accountability function, then I think there's a number of pros and cons. Obviously, vicarious liability can ensure access to a deeper pocketed defendant. That's arguably one of the key functions of vicarious liability, and it's absolutely appropriate here, but that it can come at a sacrifice of individual accountability. And the converse problem then of if jurisdictions disallow vicarious liability for really serious misconduct, really willful misconduct, or in situations, where punitive damages would be appropriate, that effectively leaves the plaintiffs who have been more severely victimised potentially unable to recover if they're restricted to suing the individual officers involved. Of course, it's the employer institution who's best placed to ensure harm prevention or minimisation, at least through its policies and procedures. But in order for that effect to occur, then institutional arrangements need to be in place so that when vicarious liability, is imposed, this sort of trickles down through training programs, through punishment of, and disciplinary, action, for example, incentivization of better conduct by prison staff and by police. But without those institutional arrangements, then vicarious liability creates a risk that civil claims become merely the cost of doing business for policing. And individual police may not even be aware that their misconduct has led to this liability and how much it has cost the state. Okay, and then I've just briefly mentioned that settlement obviously is how most of these claims end. And while this is great in terms of, access to compensation for individual, would-be litigants, there's a problem in terms of visibility here. So because settlements are typically confidential and not known to the public, again, there's an interruption of that broader systemic accountability function that would be playing out here. Because without the public reporting of these cases, there isn't that public sort of awareness of this as a potential form of accountability, and that that public kind of shaming as well of police and knowledge of the harm that they are producing and creating. So in the conclusion, I just sort of reflect on that, those main arguments, and particularly how each of these hurdles and difficulties, is exacerbated and is more significant in the case of Indigenous communities and Indigenous litigants. And then I just list a few targeted reforms that could unlock that broader systemic sort of accountability function more effectively. Access to legal assistance and representation. The enshrining of vicarious liability to ensure access to a well-resourced defendant, but the accompaniment of that vicarious liability with suitable institutional arrangements to ensure that flow-on of accountability. And finally, that transparency and visibility are crucial. And the experience of other jurisdictions, I haven't had a lot of space to draw on these in a lot of detail, but they demonstrate the potential benefits of these kinds of reforms in terms of creating that culture of watching the police, using the judiciary as a means of watching the police and holding them accountable for the ways in which they target communities and mistreat people in custody. That's it. Thank you for listening.
Well, thank you for a number of reasons, not least because you literally finished at the exact moment that my timer ran out. So that is spot on. Thank you so much. We're going to go straight into the discussion phase. We have got Tina and Sharon, who I come from the watching WWE era, and I'm thinking this is going to be kind of a tag team thing. Someone's going to jump off the top rope. It's going to be really, I don't know how it's going to work, but I will pass you straight over to Tina and Sharon.
Thank you.
Yeah, absolutely. Thank you, Sharon. If I could just jump in a bit, Laura, I absolutely loved your paper. I loved reading it. I love the topic. I love the practical aspects of it. So thank you so much for providing that to us and just writing on such a really contemporary and important topic. The way that I've approached this is just made notes about some of the strengths and also some of the sort of questions, if I can follow sort of Martin's lead of sort of asking that, and then invite Sharon to jump in with her thoughts as well. The first thing is I really like that your paper covered a range of torts as avenues of exploring civil liability. I thought you really covered a really great range there, including the trespass to the person, the negligence, the statutory duty, and the like. I thought that the case examples that you integrated really vividly explained what I'd call the sort of the tragic repercussions of what is happening. And I just say, please don't cut that, because it really, in my view, included the human element of why this is an issue and why it's a problem and why it needs to be addressed. I like the access to justice section, which I think you highlighted today, all of the challenges in accessing the legal system. It's something that I'm really particularly passionate about, including the lack of legal assistance, the representation, the emotional investment it takes to pursue these claims over periods of time. In terms of the questions or the suggestions, and I only raise this because I hope that it sort of helps to further develop the paper. My first question is, what is the target journal? Will it be a torts journal or a more sort of broader, legal studies, human, what kind of journal are you looking at?
Great question. I hadn't really given it a whole lot of thought. I was really just thinking one of the main, maybe UNSW Law Journal. I've worked with them before. I like how thorough they are. I know they'll pull me up on all my missing citations. But yeah, I'm really open to suggestion in that. I'd like to reach as broad a policy audience as possible. So I'm open to advice on what's the best way to do that.
I think that's a great idea, and the reason I flag that is because I think we're all sort of tort lawyers here, and so when we look at things like negligence and breach of statutory duty and misfeasance in public office, all of these things might come naturally to some of us, but I think that there's an opportunity to better explain concepts and the differences for the reader, because there's a lot of assumptions made at times that we will all understand, but if you're trying to communicate to that broader audience, I think that's really, really important to kind of contextualize, even just simply explaining things like you've got duty, breach, causation, remoteness as part of negligence, because I work a lot with social workers at RMIT and they've got no idea. These things just don't come naturally to them. The second thing that I would I'll also query, and I think you mentioned today, is there were a number of different avenues explored, but I think depending on the length of the paper, you might need to think about footnoting or cutting down on some of them just to make room for exploring some of them in more broader, in more depth, I should say. The third thing I would ask about is, have you thought about maybe creating a hypothetical case study at the outset? It could draw on real cases or kind of amalgamate different cases to kind of create a hypothetical that really vividly explains at the outset the issues and the problems that are experienced, only because part 2 goes into a really heavy doctrinal discussion. And I'm wondering whether just a paragraph highlighting the tragic, terrible things that happen, and then following that up with the civil liability avenues, and then including all those, you know, case examples or case nuggets that you've already integrated, might kind of help the reader to follow along and say, wow, this really is a problem, and this is why we're looking at avenues. And the final thing that I would say is, you know, have you thought about maybe sort of compensation schemes or international exemplars to see, well, how are other jurisdictions looking at systematic ways of handling this as a sort of a systematic solution, rather than sort of just because litigation is, we know it's expensive, it's time consuming, it doesn't really work, particularly for this vulnerable population. So just some sort of thoughts and suggestions, but I loved it, Laura, and I'm going to hand over to Sharon.
Thank you so much. That's really helpful.
You know, I totally endorse what Tim said there. I really loved it too. I hope you heard that, Laura.
Yes,
I really
thank you.
that.
Thank you.
When I read the synopsis, I thought, wow, you know, covering all the torts and the related remedies and the impediments to them, I thought, wow, that's really ambitious in one article. I think you do pull it off, but there are some areas where it really would have been interesting to see a bit more depth. So, for example, you refer to the fact that there's literature on race and the reasonable person. And I thought, wow, that would be a really interesting area to explore a bit more. I thought possible reforms too need a bit of fleshing out. As Laura said, should there be a statutory compensation scheme, or should there be a statutory right to compensation? Do we want to see the statutory duty of care like we have with the institutional sex abuse cases? So yeah, I just thought perhaps a bit more discussion about that would be really interesting. Please don't footnote misdemeanors in public office, because the whole article, I was really looking forward to what you were going to say about that, because I feel like it's a really interesting and developing tort that we could all learn a little bit more about, certainly me. So that leaves me, I guess, to query whether you could even get a couple of articles out of this, and whether in the end you are attempting to do a little bit too much in one article, because there's so much interesting stuff in there. And just my last point was a bit later, I was presenting on the case of the High Court decision in Lewis and the Australian Capital Territory, and I do wonder whether the decision there not to recognise vindicatory damages as a separate head of damages, and the particular way in which they apply the counterfactual analysis. I'm wondering if that actually is a further impediment to try and find Indigenous people in the cases of unlawful arrest, unlawful detention. So yeah, just wanted to mention that as something else to possibly consider. But yeah, really fantastic article, and I hope you don't think I'm being critical. I just want to see more of.
No, it's really helpful. I appreciate that feedback. I think I had this kind of awful, foreboding kind of sense of, oh no, is this meant to be 2 articles instead of 1? But I think it's tied to that question of audience, and what might be of particular interest to tort lawyers, as opposed to reaching a broad policy audience. And maybe that can be the way in which I kind of differentiate what to expand on or limit, or how to split it up. But no, super helpful feedback from both of you. Thank you so much.
are going to move on to Tina. We're going to give Tina a couple of seconds to get set up. I think we've got it on the other machine, which I can jump into if we need a bit of a hand in a moment. So talk amongst yourselves for 30 seconds whilst we get sorted.
I want to chat about that with you and the lunch break. I'm fascinated.
You I thought you were a special counsel or something.
Consultant. No.
So
What was the problem with malicious prosecution? You've got to wait till it's all done.
He might argue that there was a basis.
Yeah.
Good question.
But if it's an abusive process, sure, and we'll chat about that.
You're good to go, Tina.
Thanks so much, everyone. I'm sorry to disappoint. I'm sure my presentation is not going to be nearly as exciting or scandalous as Michael's. But welcome anyway. Our presentation co-authored with Dr. Christina Platts, who unfortunately couldn't be here today as she's in Denmark, is called Meet Me at the Altar, Consciously Coupling Tort Law and Emotion. So by way of introduction, I'm a senior lecturer at RMIT. I'm also a consulting lawyer with a practicing certificate, and I've placed some medical negligence matters over the past couple of years. I've also recently come to the light side, as I like to call it, having completed a graduate diploma in psychology at Monash University. So a lot of the emotional and psychological wellbeing things that I'm drawing on today are from that. And my co-author, Dr. Platts, is an accredited mediator as well as being an academic. She's informed a lot of the mediation aspects of the paper. So to begin with, I'd really like you to take a moment to imagine something for me. Imagine that you have a health issue that's a serious issue, something that's really affecting you. And you go to a trusted healthcare practitioner for that issue, and it could be to undergo a procedure or to receive medication or have an operation. And unfortunately, it goes drastically wrong for you, and you end up with a serious or debilitating injury that you have to live with for the rest of your life. And that can include a combination of physical injuries and psychiatric injuries. All of a sudden, overnight, you're thrust into a world that is quite foreign to you, the legal system that is long, protracted, expensive, and emotionally stressful for you. And that's very much a reality for many claimants or plaintiffs in cases involving things like motor vehicle accidents, workplace injuries, public liability claims, and the medical negligence scenario that I've just asked you to imagine for me. So these claims are certainly affected by emotional considerations, and in the literature sometimes they're referred to as non-legal, extra-legal, or non-financial considerations. If you'd like some more further case examples, I think just the last couple of years have shown us the real-world litigation examples of the types of injuries that can be sustained. So people like journalists and court reporters and lawyers working for the Specialist Sexual Offence Unit sustaining psychiatric injuries, paramedic negligence leading to brain damage, babies born with severe disabilities, and even things like plastic surgery gone wrong. And I speak on that point from experience, having recently had a case involving a breast surgery that went wrong at our firm, and very, very emotional for the claimant involved. So how does that actually play out with our legal system and the way that our legal processes deal with such claims? Well, as you can see there a quote from King stating that legal systems are often said to focus on fact-finding, determination of the law, applying the law to the facts by rules of evidence, court procedure, statutory interpretation, and case law. And these are all things that I think we as tort lawyers tend to be quite comfortable with. But what happens is that court processes often tend to sideline emotion, psychological well-being, and all of those kind of extra legal issues because they're seen or perceived to be falling outside of the court's jurisdiction. Yet despite that, studies have shown that litigation can really exacerbate the stress and trauma for litigants, and particularly those that are vulnerable with psychological injuries. I can see here an Irish study has found that two factors really exacerbate harm for both plaintiffs and doctors in medical negligence claim, including the adversarial nature of litigation and the length of the process. And further scholars have found that the legal systems have potential to enhance participation participants' wellbeing, but obviously we might not be doing such a great job of achieving that. So further research, particularly a major study by Tamara Relis, publishes a book in 2009, has found that in personal injury claims, including medical negligence claims, we might think that plaintiffs predominantly sue for money or for compensation, but the reality is that they're seeking other things. They're seeking things like voice, which is really reflected in procedural justice literature. They're seeking to have their stories heard. They're often seeking things like clarification and explanation. You know, how could this happen? To have the other person acknowledge fault or acknowledge responsibility, to apologise for the harm that's been sustained, to see justice done, and in the healthcare context, to prevent error from reoccurring. And so these adversarial processes have often been criticised for being anti-therapeutic for injured individuals. So ADR, or alternative/appropriate dispute resolution, has, you know, we've certainly been taught that it's sort of this sort of saving grace, that it's going to fix all of the problems of litigation. It's less adversarial, it's quicker, it's more cost effective. You know, it's really focused on party interest rather than legal rights, and it's got promise, it's got capacity to meet emotional needs of parties and all of these things that I've just spoken about. And the reason I focus on mediation is because in medical negligence, claims, which are claims that I sort of research in and work in, is very much a frequently used process because of the Civil Procedure Act, and also because the lists in court actually require it to be used as a dispute resolution tool. So theoretically, mediation has this capacity to deal with, you know, emotional factors, storytelling, giving the parties an opportunity to confront one another. That's all well and good. But does it actually work in practice? Well, in medical negligence claims, international studies, including Relis's Canadian study and a few other United States studies, have shown that, for instance, in medical negligence specifically, doctors rarely attend mediation. So that opportunity for closure and for emotional factors, psychological wellbeing, is not really there. I love this statistic from a paper from Hyman in a study of medical negligence mediation. 25 out of 31 plaintiffs attended, but not a single doctor attended, and I think that's incredibly telling. If I can be so bold so as to cite my own qualitative research, a study by Popper in 2018, yours truly interviewed Victorian medical negligence lawyers, including judges as well. And what was incredible all for me was that 18 out of 24 participants actually said emotion is a critical key aspect of medical negligence claims, and it's certainly relevant for plaintiffs. And then when I followed that up and said, well, okay, does mediation or ADR, does it actually allow for mediation to come to the table and to come to the forefront of these processes? They all went, oh, goodness, no, of course it doesn't. We focus on the law, we focus on tactics, we don't allow emotion into the room. And so I wanted to bring to you two quotes from that research that I find really, really powerful, because I think they really just teach what's actually going on in practice. Plaintiff lawyers too here says, the first thing is that in almost all the mediations I've been engaged with, the plaintiff doesn't enter the room with the other side. They don't get an opportunity, for mostly tactical reasons, to explain their version of events, to express their hurt, their dissatisfaction, and that's the first point. Secondly, almost all of these matters are resolved with a denial of liability. So really, how much closure can you get? How much opportunity can you get to have your piece? And then defendant lawyer 3 then says, well, the plaintiffs themselves don't tend to come into the joint session. We don't have access to them. We know they're sitting in another room, but that's the extent of it. Those that have sat in on a mediation don't tend to say anything because they've quite rightly been told by their lawyers not to say anything. So this theoretical opportunity for emotion and closure and dialogue is just simply not there. So those studies really, and with my new, love of psychology and wellbeing, have prompted me to think about, well, if that's what the literature is telling us, how can we draw on existing scholarship to look at, further avenues for, informing reform? So I've got the studies there about emotion, but I'm also drawing on therapeutic jurisprudence, procedural justice, and legal design. So very, very quickly, in the interest of time, TJ is something you might already be familiar with. It's a body of scholarship and work that really promotes and acknowledges that emotion is a key aspect in legal disputes. that we should be focusing on the emotional life and psychological well-being of those affected by our justice system, and that legal actors, including lawyers and mediators, have a critical role to play in that. Procedural justice, very famous through the work of Tom Tyler, also acknowledges that voice is an incredibly important aspect in dispute resolution processes. People have a desire to be heard, and that's particularly the case in personal injury disputes, where emotions are heightened, we've got injuries, and party voice may be critical to healing. And the new thing that I've come across quite recently and had the pleasure of working with is an emerging field of legal design. And it comes from this discipline of business and human-centered design, which is really a novel approach to problem solving that says, let's stop designing processes and imposing them on people, and let's put people at the center, at the heart of processes, and use that in the design process. Let's talk to people, let's use rich insights and see how the legal system can actually affect people so that we can better tailor solutions to the needs of those people. And that's also through the work of Margaret Hagan, and it's Lisa Toy's article 2019 also starts to bring that to the forefront. So here's one I prepared earlier in a forthcoming publication in the UNSW Law Journal, including Professor Ingo Karpen, who is an international leader on human-centered design. We actually applied this in the legal system at BCAT in an industry-funded project over the last couple of years before COVID. We really looked at going around talking to users of the system and redesigning processes to better meet the emotional and wellbeing needs of those users. And so my, thinking is how can we start to marry that legal design process with TJ, and all of the work that we've seen on emotion in personal injury claims to better redesign processes. So towards the end of the paper, while coming back from holidays, still drinking whiskey in hotel lobbies and running out of time, I put together a couple of dot points on reform possibilities. Of course, looking at legal design to look at empirical studies and a greater need to go and undertake research here in the legal system to see how can we better meet the needs of personal injury claimants. Enhanced mediator training, and that's really discussed in the paper. Christina is really quite critical of the lack of training of mediators for emotion and emotional intelligence. Lawyer education, again, that's something that we think that we learn everything about emotion and wellbeing in ADR, but unfortunately, that's sometimes not the case. And of course, other things like looking at benefits of no-fault schemes that are often hailed for focusing on things like health rehabilitation in personal injury claims, rather than just, have we got the amount of money that our lawyers want to attain. So thank you very much for listening, and here's a cute picture of a cat to say thank you.
Tina, thank you very much. Thank you for giving, well, together with certainly following after Michael's presentation, giving me flashes back to my own, one of my previous careers as a litigation lawyer, working in professional negligence, defending personal injury matters, but also trying to bring that together with, I work in sort of law tech things now, and I have thought about human-centered design in that, but never thought about putting these things together. So thank you for opening my eyes. I didn't think there'd be anything relevant or interesting for me today, and there was plenty. We have got discussion comments from yet another tag team, Michael and Laura. I don't know, have you both discussed who will go first?
No,
but
I'm happy to jump in.
As you're next to me, Michael, if you could maybe start, and Tina, would you be able to unshare that screen? Is that something you can do from there? And then we'll be able to see Laura as well. Please.
Cool. Sweet. Well, thank you very much for a great paper, Tina. That was wonderful. And yeah, I hear you did it at short notice while traveling, but it's already coming together very well. So well done. Yeah, I guess I'll make some comments, and then happy for other people to jump in. Talking about enhancing well-being as an objective of the legal system in this context, I found interesting from a lawyer's perspective. we barely think of that at all, as you probably know. It's probably different when you're acting for an injured person who's a plaintiff, but from the corporate side, I don't see that as my job whatsoever. You're completely right. It's entirely about maximising utility and getting the best outcome for the client in dollar terms. So I think your jump to legal design made sense, and I think a paper adapting the work you've already done on legal design to this particular problem, that could be, highly publishable, and that'd be good. I guess reiterating some of the points you made, I've got friends who work in Med and Eg from the insurer's side, and from their perspective, once again, their goal isn't to make the plaintiff feel better at all. Their goal is to satiate this Goliath insurance company. And the insurance company in turn, they probably don't even see the plaintiffs as people, to be honest. It's just stats on a very large Excel spreadsheet, and they're trying to minimize their exposure across a system level against the backdrop of premium prices. So for defendants, I don't see any incentive coming from them, and therefore from their lawyers, to make the sort of changes that you have explained that would be valuable. So once again, I think that is more impetus for there to be change at the system level. If, for example, if some legal design approach mandated a certain approach to mediation, then change might come. But I think, for example, the lawyer training part you mentioned, I know the uni I teach at, we have a compulsory core course on ADR that every student has to attend. They all know it, but then when they get in the firm, you do what the client wants if you're in a big organisation anyway. So it doesn't matter if they know that emotion is important. They're just going to perpetuate whatever biases are inherent in the system before. I think your point about the doctors not even coming is good, because in a lot of cases, the real respondent for practical purposes is an insurance company, which begs the question, what is the value of an apology from Chubb Insurance? Like, who cares whether or not they apologise? And I know for me, if I had a broken back, I wouldn't care what the insurer said. So I think if, for example, the doctors involved were to get in the room, it'd have to be through some sort of compulsory process of law rather than putting it onto them. Similarly, my partner is a theatre nurse, and I get war stories every day about surgeons doing crazy stuff. From all accounts, these guys are psychopaths. Like, I'm a bit of a psychopath, but these guys are really psychopaths. So I don't know if they're going to give apologies that are satisfying. Some of them will. If the goal to get them in the room is to make plaintiffs feel better, some of these guys would make the plaintiffs feel worse. They'd say, yeah, well, there was a blah, blah probability, and I did the logical thing, and you are collateral damage. And they'll just be super mathematical about it, and I don't know if that's going to make anyone feel better. So, yeah, I guess that's something to think about. Another point, a throwback to a point that came up in Laura's paper about settlements. So I know, I don't remember any settlement agreement I've been involved in that didn't involve a confidentiality clause. And so if plaintiffs are seeking some sort of vindication from the public, they're unlikely to get it if it results in a settlement. And you'd think that mediation, the whole purpose of it is to get a settlement. So that's something to keep in mind. A war story on that point, we've got this very sad lady who was wronged by an accounting firm that breached a fiduciary duty and put her interests in conflict with her aggrieved siblings. Anyway, all she wants is this apology, and we've come up with this ridiculous argument and got her a settlement of several tens of thousands, which is really good. And she won't take it because she said, it's not an apology. And we keep saying to her, they're not going to apologise. There's no compulsory process of law by which we can compel them to apologise. They're not going to. And we're at the point now where we have to cease to act because she won't accept a settlement that doesn't involve an apology. And we're like, well, we've got you the best deal we can. So I think from a utilitarian sort of perspective that insurers would follow, I think they won't have an incentive to apologise at all unless something changes. And that's even in addition to the provision of the Civil Liability Act saying an apology isn't an admission of guilt. I think even with that, they still won't apologise. So I don't know what you changed to fix that, but something might need to change.
There's a lot of great literature on apology that's resigned.
Yeah, Robin Carroll's all about that. Yeah. Anyway, they're just some ideas, Tina, but it's a great paper. I look forward to reading it in a journal one day.
Thank you so much for your feedback.
No worries.
Tina, do you want to respond to anything there before we jump on to Laura's comments?
No, I mean, it's actually such a great discussion with all the points that you've raised. I mean, they're real points, and a lot of the literature talks about, doctors, not coming because of busy schedules and all those kind of, nose and ear blanket things. That's the reality. So, there's things I'm going to have to consider when I further develop the paper. So, thank you.
No worries.
Laura, over to you.
Thank you. This was a really fascinating read. I really enjoyed it. I love the project. My first impression when I read it was that this is so rich and there's so many different elements going on that it could be a book. It's huge. And so really I just have a bunch of sort of questions or things that may be, helpful to think about. One of them is the different roles of a mediator versus a lawyer versus the courts, and what emotional or therapeutic labour is already being done by each of those. One of the things I had thought of, which echoes Michael's comments, is that sometimes providing distance from the defendant is emotional work, is an emotional protection or safeguard for the plaintiff, and so I suspect that there may already be work that relates to emotions that doesn't necessarily look like it's doing that, but it is already doing that. And then what are the potential impacts on reputation, on perceived neutrality or impartiality for each of those, role players, if they do other kinds of emotional work or engage more explicitly in emotional work. I was interested in mainly the focus obviously is on the plaintiff and their emotional needs and their emotional experience. But I was wondering if there's anything to be gained from considering the defendant's emotional needs and states as well. I'm not really sure what that would look like necessarily, particularly in medical negligence, but just sort of a general question. And on that question of the focus on medical negligence and then what the implications are in terms of generalizability, I'm wondering if the existing doctor-patient relationship sort of lends itself more easily to this idea or assertion that the defendant is rightly responsible for the plaintiff's emotions. The question of who is responsible for the plaintiff's emotions or their well-being in a case, and are we more likely to be willing to say that it's the defendant when the defendant was their doctor and there was already a relationship of responsibility for well-being in some way? But could the same be said of other cases? I don't know. What else have I got here? I found it really fascinating that one of the benefits that plaintiffs identify in terms of their involvement is that provision of impartiality and neutrality. And so there seems to be a bit of an underlying tension there between if a plaintiff wants to be able to get those benefits of this emotionally distanced, removed third party and the role that they have to play in the dispute, then if that third party becomes more involved with the emotions, does that undermine those other benefits potentially that the plaintiff is getting from that process? What else? I was wondering about if there's any potential for insights in comparison with or drawing on the literature about restorative justice programs in the criminal space. And there seems to be a lot of parallels there, and I'd be really interested to hear your thoughts on, how much of this is echoing what's going on in that space to draw on the lessons from criminal.
You've asked some really amazing questions, Laura, and I could talk to you about this for so long. I drew on restorative justice in one of the emotion papers that I've already published, and that's why I didn't want to sort of rehash it here. I drew on, I think, a US study that looks at incorporating RJ processes into MedMed. So I have to do some follow-up to see where, if there's been any further research from that, because that study is a little bit old now. And a lot of our colleagues at the Centre for Innovative Justice at RMIT do a lot of work on RJ. So absolutely. I was also conscious that the paper was already drawing on a number of different bodies of work, and like you said, it could become a book. Look, I think you've asked so many brilliant questions, and I could talk about it all day, but I'm going to shut up.
Well, don't shut up too much. Claudio has a question as well, but we've still got probably 4 minutes if we're sticking to time. So feel free to continue, Claudio.
Thank you very much. That was brilliant. I really enjoyed it. So I was wondering, in the challenge, so it's not much about
It's not so much about how to improve the paper itself, is more about the general project. So I was just thinking, because there's an inimical relationship between law and reconciliation and apologies, and because it's something that there's a philosopher, Simone Weil, and she said, well, when you fulfill your duty, you're doing something beautiful and noble and all that. When you claim a right, that's a declaration of war. You're saying, you stop there. You're saying, this is the boundary between me and you don't cross. So in the context of a procedure in which that's triggered by the fact that someone is claiming to have a right, it's very difficult to produce. But there are some experiences that are actually quite interesting. And you can use the law smartly, like yours, I think, are proposing. So the one that comes to mind is the Truth and Reconciliation Commission in South Africa. And it's actually there's morality tale there as well, because at the beginning, there were no lawyers involved. And the idea is that, look, you get a legal carrot. If you've been involved in the oppression, in the apartheid, you come to the Truth and Reconciliation, you tell the story, you face up to the people you tortured, to the relatives of the people you killed, and you talk to them, right? And there are some reports of the first 5 or 6 years in which that worked really well. It helped well to, especially in the late 90s, to rebuild some degree of mutual trust between the different communities in South Africa. The trouble is that the lawyers came in, right? So the lawyers start coming in and say, well, no, in order for you to get immunity. So the idea is that you get immunity if you tell the truth, right? So you're not going to be punished, but you have to tell the truth and to talk to the people you tortured. And there are wonderful reports about how that worked for 5 or 6 years, and then the lawyers came in. And then it was all about, no, you don't need to answer this question to get immunity. All the questions you can answer are this, and that. And then suddenly you have lawyers in both sides trying to work out exactly how you are going to. So it's an example of how this tension between legal procedure and, but also the early days, an example of how the law can be used to instrumentalize apologies and reconciliation in general. This idea that the law offered a carrot, and the carrot actually was sufficient. Then, of course, when the whole thing became more legalized, that was lost, and then the Truth and Reconciliation Commission petered out, because then there was no reconciliation to be had. It was really about, what do I need to say to get away with not being punished? And so it's more a comment than it's a challenge, yeah. So how to organize something within the legal framework that doesn't look like a declaration of war, that doesn't look like, and I think there are ways to do that, but we can only think of a few examples in which that worked, and perhaps there are lessons to be learned from those examples. Yeah.
Thank you so much for that. I've noted it as you were talking, so I can research into it and incorporate it. Thank you.
Tina, there's a question just popped up on the Q&A. Would appreciate you expanding on potential benefits of no-fault schemes regarding ideas for form. I think I've read that right.
Yes. So that was, I threw that in because...
Reform. Thank you, Andrew.
I threw that in because in some of the other papers that I've looked at, the literature really explores, no-fault schemes like in New Zealand, and I've also been over to Belgium to research their medical compensation funds and all of the benefits that come with that, particularly the focus on, providing avenues that are rehabilitating the injured people, that are focusing on reintegrating them back into society, so all of those kind of human factors. And so there's potential to kind of explore how does that work, and what can we take from that and inform it in the processes that we have here, which are so clearly fault-based and adversarial. So not a direct translation, not necessarily in relation to emotion or restorative justice, but again, sort of looking at international exemplars about what we can embed. So yeah, and France's system as well, and all of those. So yeah.
Brilliant. Thank you, Tina. We've got 4 seconds left, so that's probably time for a rousing round of applause for Tina, and with thanks to Michael and Laura.
Thank you.
Nick has designed a marathon sprint toward the final finish line. But he very kindly has put himself 7th. So we've got 3 papers now coming up between 1 o'clock and 2:30. First, we'll hear from Martin, then we'll hear from Sharon, and then, as I said, we'll hear from Nick, and we'll have discussants in each of those. So I'm going to pass over to Martin to talk about liability for injuries caused by autonomously driven vehicles. And I will say straight away, thank you, Martin, because my other hat is an AI hat, so I'm super interested in this one. Martin, over to you.
Thanks very much. I really appreciate the introduction. First, just a casual comment. You might be thinking, wow, this guy's turning up all casual, and this is how I just got so used to not flying over the COVID break that when I went to pack, I thought, don't worry, I'll just do it last minute. I didn't even pack a shirt, a business shirt, or my business pants. So I'm actually wearing my casual stuff today, but I got a jacket and shoes. Anyway, so apologies for the mismatch. Jacket and shoes is all I managed to pack. But yes, my topic is about AI-driven cars, which is really a new project for me. Most of my work has been in corrective justice in relation to psychiatric injury actions and tort, and I'm making what is known as the shift once you finish your kind of doctoral studies and get all your papers out and your books out to another sort of doctrinal area or another area to focus on, and this is going to be my area for the next while. So a bit of background. Why can't I not change the slide? Oh, there we go. Okay, so what are the new technological developments? So for those of you who aren't aware, this is a really exciting sort of area of development. So vehicles incorporating AI technology are really, they're here now, and they're getting more automated as we speak. To give you a little bit of a just overview, automation, there's an international classification by the Society of Automotive Engineers. They classify vehicles from between zero level of automation up to 5. 0 is quite clear, but levels 1 to 2 are things like that we already have now. So lane change assistance, those sorts of things. Once it gets to level 3, the car's doing much more, and the human drivers are there to respond to emergencies and that sort of thing. Once we get up to 5, it's really, really impressive because the car does everything. And the driver, in inverted commas, is not doing anything, which is the issue with when it comes to legal liability. So rapid technological development. Since 2015, national, so Commonwealth transport ministers, state transport ministers have been right on this huge number of policy developments. And in February 2022, we've just had the National Transport Commission come out with its what's known as an end-to-end regulatory framework, which we'll be discussing. Okay, so what's the potential and why are we bothering? Well, the potential is enormous. Road traffic accidents are still horrendous, impacting on every aspect of life, legal liability, the physical harm that's caused to people and the interruption to their lives, the amount of money lost. You know, you can go on and on about how much is lost through automotive accidents. And so the level 5 vehicles, ideal world, we have level 5 vehicles operating, and that's the only type of vehicles are operating on bespoke roads that have been designed for these vehicles, and they're all operating on a network, which means it's all interconnected. And hypothetically, we could reduce accidents to zero, which is incredible. But the problem is that in reality, we're going to have a very long crossover period where we've got different levels of automation in vehicles and humans, which is a problem. Humans do tend to make mistakes, and predictably so. And so for this crossover period, it's really problematic as to what we're going to be able to do. This is nothing new. We've dealt with this as a society for many, many times. So with the Industrial Revolution and the introduction of the railways, that was one of my areas of interest in my PhD. It's really, really fascinating, actually. When railways were introduced, the numbers of accidents were astronomical, to the point where they had railway doctors. In other words, doctors on the railway platforms deciding compensation claims. There were that many happening. It led to a Royal Commission in the UK, development of new safety laws and liability laws. Then the invention of the internal combustion engine, and then the deaths and the maimings really took off. But with the response to that, we had more Royal Commissions, and throughout the world, we had the development of compulsory third-party liability schemes to address the issue of uninsured drivers. No good being able to sue someone and prove fault if they've got no money to back them, and the compulsory third-party liability schemes being introduced throughout the world address that huge social issue. And effectively, we've got most of those schemes in their original form, or with slight tinkering, throughout the world still. And we certainly have that in Australia. We have compulsory third-party liability schemes. We also have, since 2011, the National Injury Insurance Scheme, which is for catastrophic injuries. And the two schemes sort of work hand in hand. I'll talk about that a little bit more in a moment. Oh, and here is where we talk about it. So in WA, South Australia, and I'm going backwards here because I'm being WA-centric, Queensland, New South Wales, and ACT, we have fault-based liability supplemented by CTP schemes. So we still have to prove fault, but once you've done that, you can be pretty sure you have access to one of these compulsory third-party liability schemes. There are threshold issues, but they're fairly minor or easily met, low bars. Northern Territory, Tassie, and Victoria, we have effectively no-fault liability schemes. Special government agencies. You have the Traffic Accident Commission here, I believe, which handles all of this. And then when you've got catastrophic injury, the National Injury Insurance regimes also kick in. They have similar threshold, legal thresholds to meet. The legal thresholds for these schemes are satisfying that there is a motor vehicle, inverted commas, so you have to go through that threshold, which in the traditional context is not an issue. You have to satisfy that there has been an accident, in inverted commas, and some of them imply that there is a driver, someone on whom to focus liability that was involved in that accident. And that is where we get to issues with some of these automated vehicles when it comes to people being injured in accidents involving these vehicles, because we don't necessarily have a human driver upon whom to focus liability. And that's really the issue that was identified early on. And so the government policy makers went on a bit of a tear from 2015 onwards, and we had a lot of really good submissions from academics around Australia as to what the issues were and how to solve them. And we're now at the sort of tail end of that process with the proposal of an end-to-end regulatory framework. So let me just go on to a little bit more detail about the particular issues with liability issues with these vehicles, because it does depend on the level of automation. So vehicles at levels of automation 0 to 2, we're talking about either no automation up to the maximum amount of automation is driver assisted lane changing. So it changes lanes and the driver can interact with the vehicle and cut it off. Those sorts of vehicles, there's no real liability issues as far as I can see in the literature. Is pretty in sync with that idea, meaning there is a driver. The driver is the human. Even when those systems are being engaged, the driver is still in charge effectively of the decision making of the vehicle. And so traditional fault schemes, traditional no fault schemes that we have are fine, because we have, in inverted commas, a driver, we have a motor vehicle, and so there's no real issue there. The issue is with vehicles at levels 3 to 5 of automation, because at that point there's a series of different decisions that go towards that get transferred towards the vehicle. And when we're talking about the vehicle, I just should say something about how these vehicles operate. There's some software, decision-making software, and then we have the actual vehicle itself. There's nothing really different about the vehicle. There's still a steering wheel, there's still brakes, there's still all the traditional mechanisms, but the software engages those mechanisms. So there's manufacturer issues. So if the vehicle's not there's errors in or problems with the manufacturer, that's potentially going to be a problem. There's software issues. So the software may have glitches and so forth. And then we get fleet operator issues. So once they start operating in fleets with a controller of the fleet, there might be issues there. And then there's consumer issues, the actual person sitting in the car, inputting data about where to go and how to travel there. So there's a whole range of different actors, in inverted commas, from the Kantian perspective, exercising free will on the creation of decision-making or the decision-making process. And then the issue becomes, where do we focus liability? So that's the big issue. Okay, so what are the issues? Fault-based liability schemes, it's really difficult at levels 3 to 5 to establish the driver has taken or has exercised a lack of reasonable care, because the car itself is making many decisions. More importantly, from a practical perspective, who do you sue as the driver? Especially at level 5, the person's really just sat in the car, programmed in the destination, and are they a driver? At the moment, the cases that have been decided have suggested no, we don't have a driver. So might we think about including software developers, the people who are developing the algorithms, because they're exercising control. Anyway, I'm taking far too long. There's some suggestions. No fault liability schemes have been suggested. They're preferred by insurers because there's no fault finding, and manufacturer liability through the ACL. I'm going to skip a whole bunch here and talk about what I need to talk about, which is the Kantian suggestion. So excuse my skipping through the slides. So the Kantian suggestion is that what we have is a right that's the juridical manifestation of self-determining agency. In other words, liability is for acts of free will, not for acts that don't involve what a Kantian like Weinberg would say action. He would call action or behavior that's not the result of action passive activity. And so we get our right to bodily integrity from that sort of concept. So I just want to talk about the requirement of fault. The requirement of fault is what is the heart of a corrective justice approach. Fault is the heart of liability, because fault is corrective justice is about correcting moral wrongs. So strict liability schemes, by their very nature, are inconsistent with this kind of idea. So that says something about the ACL proposals and also about the no fault proposals. But what it really says when it comes to motor vehicles at levels 3 to 5 of automation is that the existing fault based schemes are, the no fault schemes are not going to be principled, but that current fault-based approaches to liability are going to be effective, and they're principled at levels 0 to 2. So that for me is a good thing. But what about once we get up to levels 3 to 5? The current fault-based approaches are not going to be appropriate because they're focusing liability on a driver, in inverted commas, who isn't a driver for all intents and purposes. This legislation was developed at a time when there was no conception of someone not being a human driver in control. So it's not really tailored. The National Transport Commission has suggested that we simply define our way out of the problem by defining humans as the drivers. That's effectively summing up their approach. They've recommended that state and territory transport departments, or the ministers of transport in all the states and territories, amend their CTP and CTP legislation so that can effectively happen. But for me, that's not really, that might be kind of workable, but it's not really doing the work of the justice system from my perspective, because it's not improving the creation of risk, the responses to creation of risk. It's simply, it's a manufactured solution that helps insurers and parliamentarians. So my suggestion, and this is where I'm really in need of some help and some further development in how Kantian thinking can help us with this. But my initial work in this area has been to suggest that it's really the software developers, the developers of the algorithms that are actually controlling the vehicle, that are really exercising the most amount of free will in these vehicles. Levels 3 to 5. They're coming up with the machine learning systems. They're making the decisions effectively. They give birth to this thing. It goes out on the road and it makes decisions as it was planned to do, but it's not that thing that's making the decisions. It's been the original developer that's set those decisions in train, if you like, even though they're now far away from the actual vehicle in operation. So, but I need to do a bit more analytical work on that, and I need some help about how I further develop that. My recommendations are going to be that there be most likely the software developers take most of that liability, and that there'd be some practical ramifications to that. Software developers have some sort of insurance scheme, compulsory insurance scheme. So similar to the drivers having compulsory insurance, that the software developers have compulsory insurance. At least that means it's manageable, that technology can keep developing, people have access to compensation, and those sorts of things. And that is where I'll leave it. I look forward to some criticism and some suggestions.
Wonderful. Thank you, Martin. So unsurprisingly to anyone who's heard the way I chair these sessions, I have a lot of comments, thoughts and questions, not least, and I'm going to get in the rule of law somewhere because I always do. Most of my work relates to the rule of law and AI and what AI will do to government controls of power. And I think there's a beautiful crossover here in terms of the idea of accountability, but I'm going to park all of that to let everyone else jump in, and especially Claudio with his comments.
Thank you very much. So I told you, the breaks, I think that the proof of the pudding for all those theoretical models using seeing whether they can actually have explanatory purchase in terms of what we do. So this is really the kind of work that needs to be done now. So and I thought it was, and I learned a lot as well. So thanks for that. Automated cars, we have a certain sense of what we think, but we never systematically go through the legislation and alternatives. So this is really, really helpful. Thanks a lot for that. Oh, sorry.
So again, thanks a lot for that. And so I was making just 2 comments. And of course, the comments are not very simple; they are long. But just 2 comments. So one of them is, I was wondering. So I like your suggestion about the software developers, and I like in particular the suggestion about insurance, compulsory insurance. But I wonder if that's not actually an anti-Kantian. So I don't know really, right? So the point is this, right? Ultimately, what I think corrective justice and distributive justice were for Aristotle and the early Weinreich, the one that wrote that article in 89 in Ratio Juris, seemed to agree with me at that point. They're just rational schemes under which you explain things, right? So it's not that so you look at tax law, contribution according to income. So that's so what you have is a duty being related to a particular property that the taxpayer has, amount of money they earn, income, state, wealth, you name it. So we have two ratios, yeah. So if I earn twice as much as you, I pay even more. There's a ratio for distributive justice, and so that explains. So distributive justice explains tax law or benefit law to whom according to their need and so on. So what you have is a ratio between a duty or a right, a normative position, and a property of the individuals involved. In corrective justice, what you do is what you have is a situation in which law organizes the thing without taking into account any properties that the individuals have, right? Whether I'm richer or poorer or taller, yeah. So it's what Aristotle called arithmetic or arithmetical proportion rather than geometrical proportion or proportional proportion. Yeah. Okay. So I was just wondering. So insurance for me is typically something that actually falls into distributive justice, right? So what we have in insurance is a pool of people. You identify some properties they have. So I'm male, I'm over a certain age for traffic access. I have kids, so I pay a certain premium. People who have their licenses for the first 2 years pay more, and so on. So what I have is a situation in which I allocate the amount of money you are going to pay, not on the basis simply of each person being completely equal. I look at different proportions. So you look at the software companies and you're going to see market share and things like that. You're going to have a proportion. So I wonder if the best way to understand something like that wouldn't be distributive justice rather than corrective justice, ultimately. So it doesn't detract anything from your suggestions. But when I say I wonder, so I'm not a native speaker. When I say I wonder if, I don't mean I disagree with you. I'm really wondering if, right? I really haven't thought through this. So that's one suggestion, to think of whether insurance doesn't bring it back into the realm of distributive justice, which would not have a negative impact in the proposals you're making, because and I think that's why you have this thing. Yeah, so you have tax law and you have benefit law and you have what else? Insurance, and then you have this product liability compulsory insurance that people keep talking about in New Zealand and things like that. So what you see is a decision, a political decision at some point, to bring the regulation within the model of distributive justice rather than corrective justice. And I think that compulsory insurance is one of the ways to do that. Now, of course, that's all. The instruments for that are bilateral contracts, right? So of course, there's networks of contracts, but ultimately, what you're talking about is a very large group of people, and you're looking at them individually, or software developers or whatever, to see how much they should pay as a premium. So I was wondering if one of the ways to go around this is to think of the whole scheme as a form of distributive justice. That would be even more so, of course, if we go down the route of no fault liability, because in that case, or even outsourcing the insurance, you want to insure yourself, but here is someone is going to pay, and regardless of fault. Normally, when we make those political decisions, it has to do with transaction costs as well, yeah. Because so I was wondering, so the insurance solves one of the questions that I wanted to ask you, which is, if you have to litigate this, it is a mess, right? So you have to look at the software. There's a lot of machine learning in those cars. So the software designer sometimes couldn't have predicted a certain way in which the software develops. They could have predicted that it was unpredictable, the way the software developed, but not necessarily that it would develop in a particular way. So you're progressively more remotely related to the actual decision-making of the machine. But if you have insurance, you basically, you don't have to look into that. But I agree with you that would be a political decision to be made. And then, if I am right about Aristotle, we look at the political decision and we just use the two schemes, see which one better explains the positive law we have. This is a better explanation. That is a better explanation. Something like that. But the second point I wanted to make very briefly is I really like your idea about software developers having to take responsibility as well for because I being an old lefty in some respects, I really like the idea of follow the money, right? So they are actually probably making the most profits from the automated cars. They are selling it, so they have to make sure that they take some responsibility for what they are doing or the benefits they are accruing in relation to that. But so I really like that. But my question is whether, so how far you can go down that road, because now we have machines that are learning to learn with other machines and so on. So now we have situations in which the remoteness is so far that someone might have constructed a particular software tool now that he or she didn't envisage to be used by those cars, those software companies, and though all those bits of software, somehow they create new software. That software teaches a third software that was produced by someone else, something else. So there's a point in which, because the learning is being done by the machines rather than, there's a point in which perhaps a defense of remoteness would sound plausible. You say, look, come on, 100 years ago, my grandfather actually made some money with this thing, and he could have predicted that it was unpredictable how the software was going to grow. So I was wondering if you thought about that. I don't have an answer to that. How far down the line it can go, but because if your suggestion is picked up, that's going to be one of the issues that at some point, not now necessarily, because this is first generation stuff, but probably 50 years from now, we're going to be using machines that told machines how to do other things, and then we're going to be in the railway scenario again, something entirely different going on. But I just had to reiterate, I learned so much from your paper. I really enjoyed it, and it did the precise thing that I think the theoretical models are made for. Rather than just talking about the theoretical models, you're trying to see how they bear on problems. And again, the proof of the pudding is whether they can actually have explanatory value, they can structure our thinking, they can help us thinking more clearly about those matters. And your paper clearly helped me think more clearly about those matters. So thank you.
Very generous. Thank you for that. I've got a couple to give up. Yeah, this is a big issue. There's been some 3 or 4 papers written in Australia in the last 5 years. There's been a bunch written in the US, but an academic from Singapore University who wrote a paper published in last year's Tort journal. He talks about all the issues. The requirement to prove fault is going to be incredibly difficult. But the response to that, and this is my view, is that whenever there's been new technological development, that's been the case. And I have no reason to see why, whilst the first cases are going to be incredibly difficult, why they can't build up a body of knowledge. Think about, even not in the technological realm, how the law has responded to asbestosis, for example. An absolutely impossible scientific problem becomes legally solved through various approaches, and in particular the doctrine of res ipsa loquitur.
Yeah.
Someone brings something about, we don't really fully understand the details of how it operates, but that thing goes and creates danger in the real world. We know that it's created danger. It was brought into being by this personal set of people. We can jump over those evidentiary hurdles. That's one suggestion, and I'm not sure that addresses fully the fault aspect, which is the Kantian thing, which is it's got to be moral blameworthiness. So there might be some parallels we can draw with some of the torts that were developed, people having control of dangerous things, dangerous animals, that sort of thing. So there's some parallels. This is some of the areas that I need to keep thinking about, and I'm glad you picked that up. The remoteness issue is a massive issue. But this is my thinking about it. I'm going to explore this, and I don't know how much joy I'm going to have. But my gut feeling is that the way that I think about private law is it's supposed to create norms. It's normatively based, and then it creates norms of safety, reasonable safety, not pure safety, 100% safety. But if you're creating something so potentially dangerous, that's a really good thing to place a norm of safety or a norm of reasonable care onto. So I'm going to keep working this and try to find something, because it doesn't seem enough for me to say, well, someone brought something into being, and then which will happen, and then the stories of some of these AI-driven sort of horror stories I've been reading about. Oh well, it's just happening. I think that people need to exercise a bit more care, and whether that puts a limit on the development of technology, it probably will, but maybe for a really good reason. So I'm really excited about exploring it. So thank you for giving me some focus to that, and I'm going to, for my next couple of years, I think. I've got a question.
I was just going to say, we're pretty much out of time, but I'm very conscious. Nirav posed a question before, which we didn't get to, and that was my fault, so apologies, Nirav. It's on the screen there. If you could have a quick read, other people can probably see it as well. Or I'll read it out while you're formulating an answer. Nirav said, I can understand viewing autonomous cars as starting with software. A car has many moving parts, literally. I like that. How would you define software negligence? How can algorithmic negligence be proved? Which I think you may have just touched on. Would you favour a strict liability scheme? Will automation lead to greater centralisation? And does that influence the analysis? Great question from my perspective.
That's a fantastic question. There's so many parts that I'll try my best. How can algorithmic negligence be proved? This is one of the things that the literature's identified. Very, very difficult to do. And currently, the bar is fairly low. It's obvious areas. They've got to try it and test it out at a rudimentary level, and then once it passes the sort of fairly low bar, it gets the tick, and that's one of the problems. And so my response to that is the rate of locative response, which is that the bar is being set far too low. You're bringing into being something that's going to weigh at least a ton, and it's going around soft, fleshy human bodies. It's not enough to have that as your bar, as far as I'm concerned. So I'm going to be sort of exploring that rate to look at the potential solution to that problem, which is saying you're going to have to satisfy that this very potentially dangerous thing is going to exercise reasonable care. And if you can't do that, well, then maybe your safety standards need to be lifted. So that's my response there. I don't favour strict liability regimes, not only because they're not principled from theoretical perspective that I use, but also because they don't improve safety. The literature on strict liability schemes has sort of shown that safety standards doesn't set norms of conduct, and that's something that is really important. The norm of reasonable care is really important in this area. So I do support the fault liability will lead to greater centralisation. It is at the moment, and I'm a little bit disturbed by it, because the National Transport Commission has taken it over, and all the transport ministers are talking about it. They've got this scheme, and it defines its way out of a problem, and it's really not coming. I mean, it's a solution, but we don't know whether it's a good one or not. It's just workable. So greater centralisation isn't necessarily the solution, and it certainly does influence the analysis. I hope I answered your question, Nirav. It was a great question.
Wonderful.
Thank you, Claudia.
So I just wanted to say thank you. Unbeknownst to you, I have commenced drafting our jointly authored paper. I've got as far as the title, Public Law's Answers in Private Law's Questions. I think it's a great title. It's going to be a great paper, so thank you for not knowing you were doing it. I'd just like to say thank you to Martin, and thank you to Claudia.
So a lot of you will be familiar with the case Lewis and the ACT, where Mr. Lewis was sentenced to 12 months in prison for assault, essentially a very serious assault, but the court exercised discretion to allow him to serve that term of imprisonment by periodic detention. he failed to attend periodic detention on a few occasions, and as a result, he became liable for arrest. So it was considered to be unlawfully at large, as the High Court said. And also, he became liable for his periodic detention to be cancelled. So essentially, the sentencing board came under a duty to cancel his periodic detention, and he was required to go into full-time detention. So the board held a hearing, and they cancelled his detention, and he went to prison, and he stayed there for 82 days. Then he was able to challenge the board's cancellation of his periodic detention because he said, or was able to establish that he'd been denied procedural fairness, that some letters sent by the board about the hearing hadn't reached him. So he was granted bail, let out of prison after 82 days. He sued for damages in false imprisonment and under Section 8 of the Human Rights Act, which provides a right to damages for people who are unlawfully arrested or detained. His claim failed at all levels, and essentially the reasoning of the court at all levels was the same. First of all, the court says that the law doesn't recognise a separate head of damage called vindicatory damages, which will provide substantial damages simply for the infringement of the right. So only compensatory, aggravated and exemplary damages are available, the court said, for a false imprisonment action. And the courts at all levels applied a but-for counterfactual analysis to determine that he hadn't suffered any form of substantial loss that the law would recognise. Because the court said, well, if we look at what would have happened if he hadn't been unlawfully detained, the answer is that he would have lawfully been detained, that the board would have convened, and complied with the requirements of natural justice because they were under procedural fairness, because they were under a duty to do that, and therefore the counterfactual outcome was that he would have been detained in any event. There would have been no real difference to the period for which he was detained. There would have been no real difference to the conditions under which he would have been detained. And so the court said, well, he would have suffered the same loss anyway, and therefore he's unable to claim anything other than nominal damages. It wasn't a situation where aggravated or exemplary damages would have been appropriate. So there's two questions of legal coherence that Jason and I will be considering. The first is just the question of doctrinal coherence. So is the High Court decision in line with previous authorities, or by applying this counterfactual analysis in the way that they did, combined with the presumption of legality, that the board would have acted legally if they hadn't acted illegally, is that in line with previous authority, or is it a radical departure from previous authority, as some commentators might argue? And the second question is the question that arises out of my previous research on the illegality defence, which is whether or not, on the particular facts of Lewis, a substantial award of damages would in fact have disrupted the coherence of the legal system. Would it have brought the law of tort into conflict with the law of crime? And that comes down to the question of whether tort should recognise that loss as having a legal value. So that first question of doctrinal coherence will be addressing some really well-formulated, compelling arguments by Jason Baruha in his Before the High Court article on this case, where he argues that it's a very long-standing principle that substantial damages should be awarded for the infringement of basic rights like the right to liberty. And he argues that this is an important control against excessive exercise by governments of authority. And he distinguishes between a factual loss, which he says is subject to the counterfactual analysis. But then he says there's another type of damages, normative damages, which are awarded in law that give effect to the underlying policy and are then not subject to a counterfactual analysis. So argues that where there's an infringement of a fundamental right like right to liberty, there should always be an award of substantial damages to vindicate the right. On the other hand, the court in Lewis refers to a number of authorities where nominal damages have been awarded. So there's that question of doctrinal consistency and whether commentators like Barujas are right or the High Court is right. But what I will focus on in the remaining time, just quickly, is whether or not an award of damages to Mr. Lewis would have undermined the coherence of the legal system by bringing tort into conflict with crime. Because one possible argument is that where the criminal law has mandated that he must suffer the loss in question. So, the criminal law has mandated that he must suffer the psychological and emotional consequences that come from detention. That's the effect of the regulatory system under which he was convicted. So as soon as he breached his periodic detention obligations, he was liable to be imprisoned. And the statute required that occur. So given the statute is requiring that he must suffer this loss, would it then create an incoherence in the law for tort to provide him with damages for that loss? So it's really a question of whether or not there's that normative question to damages, which can negate a factual loss. So there's no question that he did suffer a factual loss because he went to prison and he did suffer, the indignity and so on that comes from being imprisoned. But can the law say that nonetheless that loss has no value because it would undermine the criminal law? As I said, comes out of research into the illegality defence, which looks at the sanction shifting cases like Henderson and Dorset Healthcare, where the plaintiff there was a schizophrenic who killed her mother while acting under a delusion. She sued the local authority, which was responsible for her mental health care, saying that they should have detained her. And they were negligent in not doing so. But the court said, following the earlier case of Gray, I've just gone on to the next slide and I don't know how to get back, but following the earlier case of Gray, and the court said that to recognise the claim would shift responsibility for criminal action onto the state. And that would therefore create a legal inconsistency. So I might swap to the next slide. So the corrective justice theorists, Weinrib, Alan Beaver, they would all argue, therefore, that there should be no recovery in those sanction shifting cases, because it would mean that tort law would be shifting responsibility for the crime from the plaintiff to the defendant. There's various other commentators who do say that there is a normative role to play in assessing damages, so that it's not just about whether there's factual loss, but whether in law we should recognise a loss. So it's not just a corrective justice argument. So I guess the question is, can we apply those principles here? Obviously, it's not quite as strong as the sanction shifting cases, because in those cases, the plaintiff was lawfully sentenced to a term of imprisonment or lawfully sentenced to detention in a mental hospital. So I think it's a little bit clearer. Yes, it's a little bit clearer there that the court is that the plaintiff is required to bear the losses personally, required by the criminal law to bear the losses personally, so that shifting them on to a defendant arguably creates an incoherence. Here, of course, Mr. Lewis was invalidly detained because of the failure to do procedural fairness, and so therefore there's perhaps less of an argument. But certainly, if you look at the judgment of Kiefel and Kine, there's a lot of support in there for this idea that the loss is not one that the law will recognise. Like, they talk about his liberty being highly conditional, that it was, so I'm just trying to look for the right words there. But anyway, it was conditioned on the need to comply with the current detention obligation. So the exact words are blocked out by the sharing signs. I can't quite remember the term they used. Oh yeah, so qualified and attenuated, that they suffered no loss. And they saw that as being a threshold issue, like nothing to do with but-for causation. A threshold issue, the law would not recognise a loss because he didn't have the same rights of liberty that other persons did. So in essence, the law required that he be detained. He could then claim damages for the detention in tort law. So that's ultimately the question or one of the questions that we'll be looking at. Although Mr. Lewis suffered a factual loss in law, should the law actually recognise that he suffered a real loss? Okay, well that's the key points anyway.
Sharon, you managed to perfectly confuse me. I was looking at my watch thinking you've got 35 seconds left. That was the exact wrong moment for me to look at my watch. So thank you for finishing so promptly and so much on time. The discussion we've got now is Andrew, who is in Queensland. So if you could stop sharing, that would be awesome.
All right. Can you all hear me?
Yes.
Excellent.
Yep, we can hear you.
Is it winner?
Oh, we cannot see.
Can't see you.
Yeah.
Hang on.
Put your video.
I think it's
that button at the top left might help. By all means, start, Andrew. We'll
Sure.
try and find where you are.
All right. So thanks very much for that presentation, Sharon. As you said, it builds on your book on negligence and illegality, which I think really is one of the best materials out there on the illegality principle or doctrine or defense, or however you understand it. Certainly better than my own feeble attempts to come to grips with what's really an extremely difficult doctrine that's like all over the place in terms of the court's reasoning in different kinds of cases. It's just extremely difficult, and I think your book comes to grips with it very well. I just had a few thoughts, nothing particularly well formulated, just thoughts that I had as I was reading through your book and the slides and things along those lines. So one kind of general question is, what role does coherence even have in this argument? So obviously you, and drawing on Beaver, invoke coherence as the basis for this argument about no loss being suffered. But to me, it seems like coherence is not even necessary for that argument whatsoever. And to some extent, Beaver would rather it not be necessary at all, because he doesn't want to have to invoke some separate principle of coherence. He wants to be able to explain these cases purely on the basis of the principles that already exist. So duty, breach, causation, damage, loss, things along those lines. So really, you could describe the argument without using the word coherence at all. You could say there hasn't been a loss in this situation. And it's not even that you're having to invoke coherence in order to reach the conclusion that there's no loss. The arguments, for example, that Keane makes and that Beaver makes, it's just because the law says that you are liable to have this benefit taken away from you, or you're liable to be fined or detained, that means that being detained or having a fine imposed on you causes you no loss that had any value. And in my view, that argument doesn't even require the principle of coherence at all, or the concept to be invoked. It's purely an argument about loss and the content of loss. So that was just one thought that I had. Another is that it might be somewhat counterintuitive to say that just because you're liable to have something taken away from you, that automatically it means that it's not a loss if it is taken away from you. And in some ways, the reason why the law imposes these detriments, so fine, imprisonment on people, is because it is a harm, it is a kind of loss. And particularly where the purpose of the sentence is punishment or deterrence, the fact that this is a harm that's being imposed on the person is the basis for actually imposing it. So for the law to come along and say in one area that we're going to impose this on you because it's a harm, and then in another area is saying it's not a harm at all, in a way, that seems like a kind of incoherence to me. So to some extent, I can see why Beaver makes the argument, because he, again, doesn't want to have to invoke some separate principle of coherence. But to me, it seems like even if you are detained or fined in accordance with the law, it's still a harm that you are suffering. So another point that I had, which is related to the loss-based argument, which is that there's no loss in this kind of situation, is that it seems to apply too indiscriminately. So the argument is that any sanction that is required or authorized by the law is therefore not a loss. And it just seems like that's too indiscriminate, in the sense that I think if you dig into different situations where the purpose of the sentence is being imposed, or the purpose of the consequence that the law is imposing on you, the purpose does seem to affect, to my mind, whether it would be really inconsistent for the law of torts to kind of circumvent that consequence. So to use an example, in some cases, if the purpose of a criminal sentence is to deter or punish a person, so inherent in that notion of deterrence or punishment is causing a setback to that person's interests in some way. So particularly punishment, the way you achieve punishment is by setting a person's interests back. And so if the law of torts then comes along and compensates you for that, then the punishment the punishment purpose is being completely undermined, the punishment is being reversed, and in a way is not even, the person's not being punished at all anymore. So in that situation, it does seem to make sense that if you then compensate the person for the punishment, then you're frustrating the law's purpose in that situation. But in a case where, for example, the purpose of the sentence is purely protection of the community, so I'm thinking particularly in mental health type situations where a person is having some detention imposed on them purely to protect them from causing harm to members of the community, that purpose is still completely intact if you compensate the person for their harm in being detained. So the protection has taken place, they've been detained, it's just that you can then compensate them for that harm, but compensating them in that situation doesn't detract at all from the protection that was actually achieved by the detention. And so in that sense, I think the question of coherence or consistency between the criminal law and the criminal sentence and tort law seems to, you need to have regard to the purpose of the punishment in the first place, rather than having, in the way that Beaver does, this kind of indiscriminate rule that just applies regardless of the purpose of the criminal sentence. So they were my kind of general views about Beaver's argument, which you follow as well. And the reason why I'm just coming out and bagging it is because it's Beaver's argument in a way. And so I don't feel as bad saying that to you. My final point was about Lewis specifically. the way that Keane and Kiefel describe the loss or the lack of a loss, I think that does, you're right, it aligns extremely well with the Beaver view that you also adopted. And it certainly is a very, in some ways, is intuitive in this type of situation. Although I still have this feeling that it, again, doesn't pay enough regard to the full range of rules that apply in this type of situation. So it's not just, in this type of situation, it's not just that Lewis was required to be detained and therefore, since his detention was kind of mandated by law, therefore he didn't suffer a loss. I think that kind of argument doesn't pay enough regard to the processes that the law has created that need to be followed in order for that consequence to be imposed on Lewis. And so it's not just saying he can be detained whenever. That's not what the law actually says. So it's not just he's entitled to be detained in any possible way whatsoever to have his liberty to be deprived of his liberty. There are certain processes that the law requires to be followed, such as in this particular case, cancelling the periodic detention order by the board, following through all these processes. And so in this type of situation, if you compensate him for his detention, that is in a way kind of not giving effect to, but reflects the fact that these processes haven't been followed, and that in this situation, his detention was not actually justified because these processes were not followed. Maybe we know that if the processes were followed, that he should have been detained, but they weren't followed. And so those processes have a value that if you just say, no, he gets no compensation, that detracts from whatever value you see in having these processes to ensure that sentences are only imposed in certain kinds of situation. So that was all I was thinking. And I'm not saying that none of these arguments could be overcome, because I think some of them certainly could be. But they were just thoughts that I had as I was reading it. So again, I really want to thank you for that presentation. It's really got me interested in this particular case, actually. And again, I thought your book was great, and it's good to see you building on the work that you already have done in that book.
Brilliant. Thank you, Andrew. You've still got a good few minutes to answer and go wherever you need.
Well, I think Andrew did very succinctly identify the areas where quite a bit of thinking still does need to be done. So thank you, Andrew. I absolutely agree with every point that you've made, and certainly need to think through them. There is quite a bit of discussion in the context of the sanction shifting cases in illegality about the purpose of the sentence and whether you should look at that in determining whether there would be an inconsistency in the law. So I can definitely delve into that a little bit more. I do quite like Beaver's view though, that you're looking at the intersection of tort and crime, and that if the criminal law says you've got to suffer the loss, then tort should not then provide you with damages. So I'm still sort of intuitively favouring that view, but I certainly agree that I need to look more at the arguments that you've made. And I also agree that you don't necessarily have to have regard to corrective justice or Weinrib or Beaver's view of legal coherence in order to make the same point, that if you were to argue simply that damage, assessment of damages has two aspects, a factual aspect and a normative aspect, then you can reach exactly the same end goal. Yes. In my previous research, I've kind of tended to use corrective justice and then use non-corrective justice to reach the same point and to show that they're consistent, which is something that I quite like to do, to show that you can reach the same end point without actually relying on corrective justice. But thank you very much, and they're all really important points that I need to think about a lot more carefully. So yeah, very much appreciate your commentary, and I think it's going to make it a much better paper as a result. So thank you.
Wonderful.
I look forward to reading it.
if we could say another quick thank you to Sharon and both Andrew, please. And I would be remiss in pointing out that at least as far as institutionally, Andrew is our sole representative from Queensland. There is no New South Wales institutional representative. So my barracking for Queensland in State of Origin on Wednesday is going to be on deaf ears, but go Queensland. We will go on to our final presenter, the man of the hour, albeit the man of the day. Nick, we'll pass over to you to hear about the North Britain 45 and the doctrinal origins of exemplary damages. Over to you.
Thank you very much, Paul. Okay, just give me a moment here, everyone. I'll just apologise in advance if at any moment I have to stop and clear my throat. I hope I don't have to, but I apologise in advance if I do need to at any moment. Well, I've left it till 2:05 in the afternoon to transport you all back about 250 years to the early 1760s. So I'm sorry for doing this, but I'll be as brief as possible. I'd like to thank in advance Jason Taliadoris, whose work on the history of punitive damages I read about 3 or 4 years ago, right at the very start of my PhD. Really helped formulate my thinking around the history of this doctrine. So I feel very privileged to have him in the room and offering some comments on my paper in a little while. So basically, the paper has been, I'm not sure how successfully, but I've attempted to carve it out of my PhD thesis. I tried to provide a history of exemplary or punitive damages, as they're often known, at English common law from the early 17th century to the landmark decision of the House of Lords in Lux and Barnard in 1964. The particular paper that I've chosen to present has quite a narrow scope and purpose. So rather than try to trace the development of exemplary damages at common law over a period of time, it sets out to assemble and re-examine evidence in a very short period, and for the purpose of projecting an essentially still and close up and hopefully more accurate picture. And the picture that it sets out to project is on events that occurred in 1763, specifically the companion tort cases of Huckle and Money and Wilkes and Wood. I say companion because both cases arose out of a single controversy, and I might just spend the next couple of minutes speaking to that controversy before getting to some of the arguments some of the historical arguments that I make in the paper. So the common or single controversy in Huckle and Wilkes can be summarised as follows. So in late April 1763, the 45th issue of the controversial anti-government newspaper, the North Britain, was published. And the number 45, as it's often referred to in the historical sources, had severely criticised a speech that the reigning monarch at the time, George III, had recently delivered to Parliament. And those, mainly British Tories, indignant towards the North Britain newspaper, whose authorship, I might add, was officially anonymous, needed little convincing that the most recent 45th issue of the newspaper was a seditious libel. And this led the government of the day deciding to prosecute the number 45 under the state's criminal seditious libel laws. And the government's prosecution was put immediately in train by the Secretary of State, Lord Halifax. And Halifax's first move was to issue legally, indeed constitutionally controversial general warrants, whose purpose was to target those that the prosecuting government suspected of having been involved with the number 45. And those who were targeted included the number 45 suspected author, the famous Whig parliamentarian and radical journalist John Wilkes, as well as one of the well-known London printer Dryden Leach's journeymen or apprentices, William Huckle. So after they were both detained by messengers of the king, and in Wilkes' case had his private papers seized, Huckle and Wilkes both brought trespass actions in which they sought substantial damages. Huckle brought his action against the royal messenger who had executed Lord Halifax's warrant at Dryden Leach's printing workshop, John Money, and Wilkes brought his action against Lord Halifax's deputy, Robert Wood, who had overseen the occupation of his house by messengers of the king and the collection of his private manuscripts. So both of their claims, Huckle's claim and Wilkes's claim, were tried before Chief Justice Pratt, the then Chief Justice of the Court of Common Pleas, and two special juries in 1763. Huckle recovered very large damages of £300 and Wilkes recovered very large damages of £1,000. So that's the controversy that I wanted to set out at the very outset. Now, Chief Justice Pratt's North Britain decisions loom large in the common law mind about the origins of exemplary damages, if any of you have thought about them or thought about exploring them. And when modern writers on exemplary damages allude to their origins, which they often do, Huckle and Wilkes are cited as a matter of course. So any historical discussion, I quickly realised as an early PhD researcher of exemplary damages can hardly avoid reference to these two cases, Huckle and Money and Wilkes and Wood. But in referring to them, Chief Justice Pratt's companion North Britain decisions are credited for providing the award of exemplary damages a positive basis at English common law, right? But rarely, I found, did many modern writers try to explain how Chief Justice Pratt's decisions in Huckle and Wilkes recognised exemplary damages as a positive matter of English common law, and it wasn't immediately apparent to me. So I want to explore in the next couple of minutes the how question, right? The how question with respect to Huckle before exploring it in respect of Wilkes, and in doing so, I'll hopefully make clear some of the historical points that I make in the paper. So it's often noted that in Huckle, which was decided before Wilkes, Chief Justice Pratt is the first English judge reported to have used the now familiar phrase exemplary damages, right? And he did so in the course of an in-bank or appellate motion where the losing royal messenger, Money, sought to have the Huckle jury's verdict set aside, quashed, solely on the ground of the excessiveness of their £300 damages award. And in the course of denying the defendant's in-bank motion, and therefore upholding the Huckle jury's verdict, Chief Justice Pratt is reported to have said the following, which I'll read out, very short. I think they, the Huckle jury, have done right in giving exemplary damages. Now, Huckle's positive lawmaking significance, if you like, is supposed to lie in Chief Justice Pratt's mere use of the phrase exemplary damages, right, which has been described as comprising its first use as a formal legal doctrine. Now, it wasn't clear to me exactly what is meant by the phrase exemplary damages being used as a formal legal doctrine. What it may mean is that Chief Justice Pratt used the phrase because by the 1760s, by the time these cases were being decided, common law judges had started thinking about the question, excuse me, had started thinking about the question of the determination of damages in tort actions as involving the use of legal damages doctrines or rules. So specifically in aggravated tort actions, they had started thinking about the determination of damages as involving the use of an extra compensatory, broadly punitive doctrine or rule of damages. So if this is what is meant by Chief Justice Pratt using the phrase exemplary damages in Huckle as a formal legal doctrine, I suggest in the paper that this interpretation of Huckle is open to question. What I argue in the paper is that during the period in question, common law judges and Chief Justice Pratt in particular were still a very long way away from thinking about the question of the determination of tort damages, especially in aggravated cases in this way. That is to say, as involving the use or application of an extra compensatory doctrine or rule of damages. So on this point, I think it's important to clarify, and I make this point in the paper, I think it's important to clarify what the motion for a new trial on the ground of excessive damages involved as a species of post-trial review. Via this motion, I try to clarify, which the losing royal messenger had brought in Huckle, losing tort defendants did not ask reviewing courts like Chief Justice Pratt's reviewing common pleas to determine whether the jury had been lawfully allowed to award the plaintiff exemplary damages. But that is what they weren't about. I'd argue that the courts were simply invited via this species of post-trial motion to deliberate over the underlying justice of the jury's damages award. And if the judges in Bank came to the view that a jury's award was so excessive, so out of proportion, so as to be unjust, they might set the verdict, excuse me, they might set the verdict aside and grant the defendant a new trial. That is to say, the opportunity of having a new jury impaneled, having the facts of the case tried afresh, and a new award of damages being given. But as I emphasise in the paper, well into the second half of the 18th century, common law judges like Chief Justice Pratt were reluctant as ever about setting aside allegedly excessive tort verdicts. Right? It was an appellate jurisdiction that they were very ambivalent about, and this was because they saw intermeddling, or I should say, they saw setting aside a jury's verdict on the ground of excessive damages as illegitimately interfering in a province of common law tort adjudication that belonged solely to the jury, and this involved the question of the determination of damages. And I argue that Chief Justice Pratt's Huckle speech really exemplifies this extreme judicial reluctance at the time to interfere with the jury's adjudicative competence over the question of damages. In fact, I think it's more plausible, excuse me, I think that the more plausible explanation of Chief Justice Pratt's use of the phrase exemplary damages, which is what he's often singularly focused on, was not because his common pleas had started to think about the question of whether in aggravated tort cases, exemplary damages could be recovered as a positive matter of English common law, rather than using it, therefore, with the aim of articulating any formal legal doctrine of exemplary damages. I think the better interpretation is that Chief Justice Pratt used the phrase in support of the jury's adjudicative competence over the question of damages. And as I argue more fully in the paper, a closer examination of the report of the government's in-bank motion in Huckle shows that at the trial of Huckle's claim, which had occurred in July 1763, George III's Solicitor General, Sir Fletcher Norton, who had appeared for the trespassing royal messenger, had tried effectively to remove the question of the determination of damages from the Huckle jury's adjudicative province, but in trying to limit the government's liability to this journeyman printer in damages, he even told the Huckle jury that the common law bound them to strictly determine Huckle's damages according to the injuries he had suffered. And from Chief Justice Pratt's point of view, it seems, by ultimately giving very large and apparently exemplary damages of £300 to Mr. Huckle, the Huckle jury had done right to rebuff how the Solicitor General had engaged the question of damages with the Huckle jury. And on the basis of that rival interpretation, which I set forth in the paper, I conclude that Chief Justice Pratt's mere use of the phrase exemplary damages in Huckle did not comprise and should not be understood as having comprised its first use as a formal legal doctrine. But this leaves Chief Justice Pratt's decision in Wilkes and Wood, and which came very soon after his Huckle decision. Unlike Huckle, Wilkes was a trial decision rather than an in-bank appellate decision. As for its positive lawmaking significance, well, it's supposed to lie in a direction or instruction that Chief Justice Pratt is supposed to have given to the Wilkes jury before he submitted John Wilkes's trespass claim to them. And I'll read out in full what Chief Justice Pratt said to them, and that has been interpreted as comprising a direction or instruction with respect to damages. Chief Justice Pratt said, "I have formally delivered it as my opinion on another occasion, and I will continue of the same mind that a jury have it in their power to give damages for more than the injury received. Damages are designed not only as a satisfaction to the injured person, but likewise as a punishment to the guilty, to deter from any such proceeding for the future, excuse me, and as a proof of the detestation of the jury to the action itself. And as I've said, the prevailing interpretation of that passage is that with his recent Huckle speech in mind, Chief Justice Pratt purported to give the Wilkes jury a direction regarding the question of damages. And according to Chief Justice Pratt's direction, as a positive matter of English common law, the Wilkes jurors were now allowed to determine Wilkes's damages, not just to compensate him for the full extent of his injuries, pecuniary and non-pecuniary, but to make an example or otherwise punish Wood, the defendant, Lord Halifax's deputy. Or to put it differently than that, Chief Justice Pratt was now choosing to lay down to the Wilkes jury a new common law damages doctrine, one that his court had recently started to articulate in bank from the Central Common Pleas bench. Similarly, I argue that that interpretation of what Chief Justice Pratt said apparently to the Wilkes jury about the question of damages in his summing up of the case is also open to question. And I suggest that the above statement that I've read out may not have been aimed, certainly not exclusively to the Wilkes jury at all. And the key, I think, to a correct interpretation of Chief Justice Pratt's statement is to view it again, right, in the particular context of the Solicitor General's repeated attempt, the evidence shows, to remove the question of the determination of damages, this time from the province of the Wilkes jury. Right? So on that point, I think it's significant that Chief Justice Pratt referred to the question of how damages are to be designed as something that the jurors have in their power. And this, I think, makes it quite plausible that Chief Justice Pratt, and there are other reasons I give for reaching this conclusion, but I think that among many makes it quite plausible that Chief Justice Pratt was not intending to legally direct the Wilkes jury's determination at all. Instead, he was seeking to counteract a further attempt by the Solicitor General to bind their determination strictly to the injuries that Wilkes had suffered. So in conclusion, I know I've run a little bit over time. In conclusion, what I try to do in the paper is cast doubt over the proposition that the modern common law doctrine of exemplary damages that private law theorists have criticised to the nth degree, really, came into being uno ictu at once in 1763. I think this is highly implausible. Chief Justice Pratt's references to extra compensatory recovery, first in Huckle, then in Wilkes, did not, I argue, recognise exemplary damages as a positive matter of English common law. Instead, I think he referred to extra compensatory, exemplary or otherwise punitive damages in an attempt to make sure that the Huckle and Wilkes juries would determine the question of damages in their own province. And in their own province did not mean by them applying legal damages doctrines laid down to them by common law judges like Chief Justice Pratt. It meant according to their own sense of what justice demanded in each case, entirely free of legal doctrinal strictures and controls. And if my historical reinterpretation of Huckle and Wilkes is correct, and I think it might be correct, it's more likely that the modern common law doctrine of exemplary damages arose at some point after 1763 and by slower degrees than has been fully recognised or appreciated. So that's my presentation. Thanks very much for listening.
Nick, you were right. You did run a couple of seconds over, but we will forgive you for that, for what the Dean of Michael's Law School referred to as the impact of the spicy cough. So yeah, thank you for pushing through that. It is greatly appreciated. We're going to hand over for the penultimate word to Jason to comment on the paper.
Thanks very much. Thank you, Nick, for inviting me to this workshop, and thanks for your kind words of acknowledgement. I feel humbled to have played a part in your intellectual journey, and I can only say it's a fantastic paper that I've read. Your presentation confirmed that. I'm convinced, by the arguments you've made. I think everyone who's had a look at the paper would have seen the depth of research, the fine-grained reading of what are extremely difficult sources. These 18th century cases, we kind of, when we're reading these decisions, we equate it, or we may equate in our minds with reading a contemporary High Court decision, where all the reasoning is written out plainly. These were literally reports of cases. So, we don't have the judges themselves necessarily putting their pen to paper in the way that we do today. So, I want to say a couple of things about your findings. I also want to make some 4 broad comments. First of all, about the usefulness of an historical approach to that Nick has taken in his paper, and why it's so important and how it can be useful. So as we've seen from Nick's close reading of these twin decisions relating to the North Britain number 45, there's and having close regard to not only the difficult language of the reports, the particular nature of how these reports are produced, but also the social context, the political context in which they were produced, produces a kind of revisionist reading of the relevance and the significance of these cases. So Brooks and Barnard, so the key Australian cases, have just accepted for a century or more the foundational principle that these 2 twin cases stand for the source of the doctrine of exemplary damages. You've unsettled that, I think, quite successfully, not only in this paper, but your Journal of Legal History paper that was published earlier this year, which I also read with great interest. Just commenting on the usefulness of this historical approach, which I guess can add to our understanding of the law, the development of the law, in terms of if we're looking for patterns in the law, the coherence of the law, and I'll use that term coherence in a broad sense, not in the particular Beaver sense or other particular legal theoretical senses that it's used. Looking at the history of the development of a doctrinal law can inform arguably how that principle should develop in the future, or how it should be in the future. So I think there's usefulness there. The other thing about historical research of legal doctrine is sometimes it can identify patterns of thought that lead to a current doctrine in law. But other times, as Nick has demonstrated here, it can actually demonstrate that there are no necessary intellectual patterns, and that history is, it's discontinuous, it's contingent. It doesn't necessarily lead in this kind of Whiggish, line of continuity and progress. History is messy. So often as lawyers, we want to draw a line between a developmental line between something in the past and something in the present. And history unsettles that kind of idea of wanting to do that in many occasions. So I want to commend you on your paper, Nick. I have 2 observations that I want to make. First of all, I just want to invite you to consider, yes, I agree with the substance of your argument that Pratt's judgment on your reading perhaps doesn't demonstrate a doctrinal kind of attempt to necessarily articulate the notion of exemplary or punitive damages. But there are perhaps some normative features in his words, such as the notion of reasonableness, because even with the types of a new trial or instructions to the jury, judges such as Pratt could be influential, could exert their influence on the determination in that way. And if the award was totally unreasonable, then that would be a basis for overturning the jury's verdict. So just be sure to emphasise that, I think. The other, I guess, things I wanted to add, my own work has looked at the possible sources for exemplary damages going right back to the 10th and 11th century, but most particularly looking at 13th century statutes, which I argue were highly influential on 18th century legal thinking. There's a legal textbook that came out by Sawyer just after the decisions, these twin decisions in 1770, I think, which look backwards to these 13th century statutes when trying to explain the notion of exemplary damages. So it was almost, at the time, textbook writers weren't seeing their own period as necessarily a formative one in notions of exemplary damages, but we're looking backwards, back to medieval sources. And the other interesting developmental notion is in the law of defamation, which I started to look at, but I think still requires some exploration, because the notion of extra compensatory damages as compensating someone for loss of humiliation or loss to their feelings is still something that I was really interested when I was looking at this from a longer perspective, and I still don't think has been completely researched. So I guess my next invitation to you is, if not in the twin cases of 1763, where is the Fons Origo for exemplary punitive damages? And I'll leave my comments there, and again commend you for a fine paper. Thank you, Nick.
Jump in and add any responses?
Yes, thanks very much, Jason. I really appreciate your insightful comments. You make a very important point that although judges didn't think of themselves during the period under examination as administering positive common law doctrines that they would lay down to juries as part of their final submission of the plaintiff's case to them, they did nonetheless exert a very strong influence, albeit in different ways. So I think the device of judicial comment on the evidence, which has a long history and it's referred to in treatises dating back to the 17th century, is very important. So though judges, and there's very clear evidence of Chief Justice Pratt using this device in his summing up to the Wilkes jury, where a judge will, often it appears quite tactfully, emphasise certain points in the evidence, and in an aggravated tort case that might involve emphasising certain points that a jury might act upon in deciding to weigh very heavily on the defendant in damages in order to procure an outcome that would be satisfactory to the particular judge. So there is definitely evidence of that. It's very difficult to find that kind of evidence in the period in question because we don't really have any systematic reporting of trial or nisi prius tort cases until about the 1780s and 1790s. So we're still about 20 years away from being able to look at how reporters were, what we find in reported trial decisions about how judges were engaging with juries on the question of damages. So for example, in Huckle and Wilkes, Huckle itself was an in-bank appellate case, and it's only really a sheer accident that John Wilkes's trespass claim happened to be reported at the time. I mean, so what Chief Justice Pratt said to, or supposedly said to the Wilkes jury, might have well been something that was just never written down. We would have had no written record of exactly what Chief Justice Pratt decided to tell the Wilkes jury before submitting John Wilkes's case to them. So that makes it a little bit hard to detect a general pattern of how common law judges engage with juries on the question of how heavily to weigh on an aggravated defendant in damages during the period in question. To the last point you made, Jason, about if not in 1763, then when? Well, in my PhD research, a lot of which still hasn't been published, I suggest that we don't really see a positive common law doctrine of exemplary damages emerging until the middle of the 19th century, where there were a wider set of ways by which aggrieved tort defendants could challenge the decision of a trial court. So via, as I say in the presentation in the paper, via the motion for new trial on the ground of excessive damages, the defendant's sole complaint was that the damages were too big. But there was no complaint to the trial court about what the trial judge decided to tell the jury about how to engage the question of damages. So it's not until the 19th century where we see motions for new trial on the ground of judicial misdirection. And I argue it's out of that alternative appellate procedure that the modern doctrine of exemplary damages at common law should be regarded as emerging. But that's something I will hopefully get to in a paper in the not too distant future, Jason. But that's just a bit of a projection looking forward. But yeah, again, thank you very much, Jason. I appreciate it. Yeah.
Thank you, Nick. Well done.
Thank you, Nick. And if we can say thank you to Nick and Jason just one more time, please. Before I pass back to Nick to have the final word, and apologies for starting to close things out a few minutes over. I've failed in my chairing duties. Kind words were said about my timekeeping, and it's all gone 4 minutes over, and I know. So today's session has been called Researching Tort Law in Australia with the Essential Colon, Emerging Voices, Fresh Perspectives. And I, for one, well, today has been absolutely wonderful. And I say that as a not talks person. I can only imagine if I knew vaguely what people were talking about, how much better it would have been. I was brought in, as Nick suggested, quite late in the proceedings. I was planning on coming anyway. I wasn't planning on playing a substantive part, but it's actually been a huge privilege to be part of today, and not just because I've got to meet some lovely new people and have a delightful dinner last night, which was great. But today's workshop, today's papers have done something that very rarely happens. There's been this amazing breadth of topics that have been covered, but it's been coherent, it's made sense, and it's been interesting to listen to. So we've looked at the past, and we've looked at the future, and we've looked at theory, and we've looked at practice. And there's been the general thread of tort, that goes without saying, but it's all hung together really well. And there's been this wonderful synergy that Nick's been able to put together between the papers and the discussion. So thank you everyone for taking the time, obviously, to put the papers in, and for doing the discussion role, which I know actually is sometimes harder than actually writing the paper. In relation to sessions like this, and we mentioned all the thanks at the beginning, I'm going to say it very quickly again, because these things don't happen by accident. Certain people have traveled a very, very long way. I'm thinking specifically of our WA colleagues. But of course, the attendees, of whom there have been quite a lot online throughout today. So thank you to them for coming along. Thank you for those writing papers. Thank you for those commenting on papers. Thank you to the secret admin people in the room next door. They've done a great job of running in when we've had our technology foibles. Claus for providing the funding for the whole day. That has been absolutely wonderful. And Nick, thank you so much for pushing through injury, disease, and everything else to bring together such a really tremendous day. So if we can say a big thank you to... And Nick, I'll pass over to you to say the final words and close things out.
Thank you very much, Paul. Well, I won't ask everyone to do another round of applause, but a lot of credit has to go for Paul for coming in at very late notice and stepping into my shoes and doing a fantastic job, I thought. So thank you again, Paul, for your efforts today. And to everyone who participated. I think we can only really judge the success of this according to what we set out to do at the very start, which was just to bring a bunch of people interested academically in tort law and have them discuss their ideas, really for the purpose of not necessarily getting the most rigorous or critical feedback on our work, although I think we managed to achieve that as well, but just to get to know one another, put faces to names and the sound of voices to names as well, which we often don't do when we're just perusing each other's profiles on university websites. And hopefully this can be the beginning of more events like this in the future. It's unfortunate that I wasn't able to be there in person and get to know many of you on a less formal basis during the morning tea and the lunch break. But I feel like I have had a chance to connect with you, albeit via Zoom virtually. So again, thank you to everyone, especially those who have travelled from further afar. And I look forward to similar events like this in the future. Thank you again. And of course, thank you to Claudio in particular, who, it's really to you, Claudio, who, I mean, if you weren't coming to, if you hadn't chosen to visit Melbourne, who knows whether this would have happened. So, but no, that definitely was the motivation for putting on an event like this. And I think we've pulled it off quite successfully. So thank you very much. Cheers.